Comments பண்ணலாம். Time ஆயிடுச்சுல?
Yes.
Yes, sir.
Good morning, friends. Today we are going to have a very vibrant session on electronic evidence and its proval in the court of law. For that, we are having our Honorable Director of State Judicial Academy and our IT Registrar today along with us. Friends, I humbly request our Honorable Director to give our welcome address.
மத்த மைக்கெல்லாம் மியூட் பண்ணிடுங்க. Okay. A very good morning. I welcome the resource persons and the participants who have joined this refresher program on cyber laws, appreciation and handling of digital evidence for judicial officers. This is the ECT program number 14. I welcome you all for this program. This program is devised for better equipping the judicial officers for being upright to the digital world. The study of cyber laws is very fascinating. Digital advancements and growth of the cyberspace has touched every aspect of our lives, and courtrooms are no exceptions. Every action and reaction in cyberspace has some legal and cyber legal perspectives. Therefore, cyber laws have its fabric extending into all the branches of law. Cyber laws in India have been evolving since its inception and have gained more traction with the increasing advancement of cyberspace. Today, the Indian Evidence Act has evolved itself to harmoniously accommodate the cyber laws in India. The importance of understanding Indian Evidence Act and Information Technology Act has been well documented and reiterated by our courts from time to time. In today's techno-savvy environment, the world is becoming more and more digitally sophisticated, and so are the crimes. Internet was initially developed as a research aid and information sharing tool. As time passed, it became increasingly transactional with e-business, e-commerce, e-governance, and e-procurement, etc., which required more regulation. All legal issues related to internet crime are dealt with through cyber laws. As the number of internet users is on the rise, the need for cyber laws and their application has also gathered great momentum. As observed by the Honorable Supreme Court of India in the case of Arjun Panditrao Kotkar, handling digital evidence in courtrooms raises crucial and novel questions and challenges which requires a careful attention. The prime objective of this program is to refresh our knowledge pertaining to the basics of electronic evidence and sharpening our skills on appreciation of digital and electronic evidence. We are confident that this program would revitalize your skills and enable all of you to better appreciate and handle digital and electronic evidence. I urge all the participants to make best use of our resource persons, Mr. A. Saravana Kumar, Registrar IT cum Statistics, High Court of Madras, and Mr. Mithun Kumar Allu, an advocate practicing in the High Courts of Hyderabad. I wish everyone a fruitful learning and understanding. Thank you. Over to you, sir.
Yeah, நன்றிங்க, ரொம்ப நன்றி. Friends, once again, good morning for all. Please mute your mic for better understanding and also for seamless connectivity. Brothers and sisters, today amidst we are having our Registrar IT, a vibrant person and improving more in electronic evidences. I welcome you, sir, for this wonderful first session on basics of electronic evidence. Friends, it is a new thing if you think. Please keenly understand the materials which have been profoundly passed on you. Now it's time. Sir, please adorn the stage, sir.
Respected Director, Tamil Nadu State Judicial Academy, respected judges, OST Mr. Naharajan, Very good morning and warm wishes to all. At the swipe of everyone's finger, nowadays a techno-savvy exists. Needless to say, virtual world is nothing but a fantasy world. But in practice, there are several crimes are committed through several devices. Needless to say, it is a training program conducted by as per the direction of Honorable E Committee of the Supreme Court, as well as the Computer Committee of our Honorable High Court, with the approval of the Board of Governors, Tamil Nadu State Judicial Academy. So far as this training model is concerned, we have taken 3 subjects into consideration. Firstly, our judicial officers must have some foundation knowledge as to where the real digital evidence are located. So with an intent to cater that need, the first session under the caption Basics in Electronic Evidence is propounded. Once such evidence is retrieved or traced, the next stage is to produce it before the court. That is the digital evidence in courtroom. Then comes the admissibility and proof of the various digital evidences. After the evidence is produced, the next question is how to preserve it in the court, so that the second and third subjects are captioned as cyber laws as well as the digital evidence in courtrooms. Next. Yes. Yes. Whether a technical knowledge to a judge is required? The first question for every judge is, do I really to know this? The answer is yes, absolutely. Because once we see the characteristics of the electronic evidence, we can say that a basic knowledge as to the electronic evidence is very vital for every judge. The important characteristics of the electronic evidence is, firstly, it is immiscible to eye. It is immiscible to eye. Second is, it is easily alterable or customized. Thirdly, each steps require a special tool or equipment for retrieval. Fourthly, to come to or to arrive at a correct conclusion, it requires expert testimony. Fourthly, the process must be understandable by a judge. So these are all the characteristics of electronic evidence when it is produced before the court. Therefore, what we feel is having some technical knowledge gives a good edge in the appreciation of digital evidence. Therefore, a little technical knowledge would be just wonderful for a judge to appreciate the digital evidence. Taking into consideration of the basic knowledge about the computer science, the Honorable Supreme Court in the case of Vijayendra Kumar Verma versus Public Service Commission Uttarakhand, 2011 1 ACC page 150 has observed that the Indian judiciary is taking steps to computerize its own courts. Therefore, at the entry level of the judicial officers, basic computer knowledge is necessary, and therefore, one paper or one exam paper for computer science can be introduced. Having realized the same, the Honorable Supreme Court has held that a basic computer knowledge for every judicial officer is necessary. Next. So before going into the subject, next slide. As a prelude, we have come across several cases both in civil and criminal matters. In a crime scenario, any cyber criminal inevitably leaves behind its traces on the network or logs. Computer devices and computer network are the three places where digital evidence may be located or found. The type of evidence that is available at three places would differ significantly. Moreover, digital evidence can be available as files stored on a computer like text, image, audio, or video. Moreover, a cyber criminal cannot delete wrongdoing by deleting any files, because all deleted files can be retrieved. Now we have to see next. What is electronic evidence or electronic record? Indian Evidence Act is one of the old pieces of legislation in India. Thanks to the wisdom of its legislature, though the act has become old, it is not outdated. The amplitude of the language, expressions, words used in the Indian Evidence Act still cater the need of the growth of science and communication technology. Once any lacuna is found, the Supreme Court or the High Court comes into the picture and interprets the law. And the legislature is also making necessary amendments in the Evidence Act so as to suit the modern condition. One such amendment is made in Section 3 of the Indian Evidence Act, which says evidence means all documents, including electronic records, produced for the inspection of the court. Therefore, it is made clear that evidence includes electronic record. The next question is, what is electronic record? Section 2T of the Indian Evidence IT Act defines what is electronic record. Electronic record means data, record, or data generated, image or sound stored, received or sent in an electronic form, or microfilm or computer generated microflash. For the purpose of easy understanding, we can read this section from back to front. Now we have to see where the electronic evidence, how the electronic evidence is available. The electronic evidence is available in an electronic form or microfilm or computer generated microfilms. How it is processed? It is generated, stored, received, or sent. What is the medium of electronic records? It's maybe a data, image, sound, etc. Next. So an analysis of next. Next. Before. Okay. Next. Now, since we have seen what is data, it is better to understand the definition of data as defined under Section 2O of the Indian Evidence Act. Data means a representation of information, knowledge, facts, concepts, or instructions which are being prepared or have been prepared in a formalized manner and is intended to processed or is being processed or has been processed in a computer system or computer network and may be in any form including computer printouts, magnetic or optical storage media, punched cards, punched tapes are stored internally in the memory of the computer. Therefore, data is a representation of information, knowledge, facts, or concepts, or instructions. How it is prepared? It is prepared in a formalistic manner. What is going on through data? It is processed in a computer in any form or stored internally. Next. Now the question is, what is computer? Section 2I of the Indian Information Technology Act defines what is computer. Computer means any electronic, magnetic, optical, high-speed data processing device or system. It performs logical arithmetic memory functions by manipulations of electronic, magnetic, or optical impulses. It includes all input, output, processing storage, computer software, and or communication facilities connected or related to the computer in a computer system or a computer network. So once we see the definition of the word computer, it is inclusive in nature. It defines what is computer. It tells how the computer performs. It also says what the word computer includes and how it is to be connected. Next. So the analysis of section 2I says that it is an inclusive definition. It defines what is computer, how it performs, through which it performs, and what inputs. Therefore, a computer can be a tool for commission of offense, or it can be a repository of electronic evidence, or it can be an object of a crime. So it need not be considered that only through a commission of an offense can be committed by through a computer. It can be used as a tool it can be a tool for the commission of an offense, or we can retrieve certain records, electronic records, as it is a repository or storage of electronic evidence, or an offense can be committed in respect of a computer. Next. Then what is computer system? Section 2IL of the Information Technology Act defines what is computer system. A reading of the section would say that a computer system means a device or collection of devices. It includes input and output devices. It excludes calculators which are not programmable. It can be used in conjunction with external files which contains computer programs, electronic instructions, input data and output data. It performs logic, arithmetic, data storage, retrieval, communication control, and other functions. Next. Yes. The word computer system is of wide amplitude. It can include computer system of all sorts, including mobile phones and all mobile gadgets. A computer with additional hardware and software together is called computer system. A computer system comprises a CPU, memory, RAM or ROM, input-output devices such as keyboard, mouse, monitor, printer, and storage devices, hard disk, drive, external hardware, external hard disks, etc. All these components function together as a single unit to deliver the desired output. Therefore, these are all the definitions relating to what is computer, what is computer system, and what is electronic records. Now, the next question that arises for consideration is where we have to search for digital evidences. All of you would know very well that the software is the brain of a computer. The hardwares are making the software to work. That apart, internet connectivity gives an access to the other devices installed in the different locations. So the hardware, software, and connectivity are the main areas where the gold mine of the electronic evidences are available. In order to understand better, we have to analyze what is hardware. Next. Yes. Hardware includes physical components for inputs and outputs and physical components for data retention. The physical components for inputs includes mouse, keyboard, touch screen, or any other physical device through which data fed into computer. Physical components of output devices includes display board, monitor, printer, etc. The data retention is most crucial function of any computer. The retention ability of the computer is not only utilized for storage of data, but also its operating system and applications to run the system. As you know, that there are different kinds of storages in the computer system, of which two are very important. One is external storage and internal storage. So far as the internal storage is concerned, hard disk drive plays an important role. Next. Because next, hard disk drive is a significant source of electronic evidence. How? The reason is the computer hard disk is the main source of electronic evidence against such crimes as it maintains digital information on it. Since the hard disk contains digital information on it, it plays a vital role in retrieving evidence, electronic evidence. The devices could be used as an evidence in the event of prosecution. In several cases, in day in and out, the hard disks are produced before the court so as to prove the case of the prosecution. So a basic knowledge about the hard disk, which we must know. So as I already told you, that hard disk can be both external and internal. It may be an internal hard disk or external hard disk. Internal hard disk means it is integrated into the computer system itself. It is available there in the computer. External hard disk is attached through USB ports, which includes pen drive and flash drives. The basic storage location of every computer is hard disk drive. In Kishan Tripathi versus State 2016 230 DLT CN3 Division Bench, the Honorable Delhi High Court has held that hard disk is not merely a physical object, but it is also a document within the meaning of Section 3 of the Evidence Act. So, many of the trials, the hard disks are produced before the court. But the moment a hard disk is produced before the court, we cannot say that it can be believed or it has got authenticity. Next. Yes. The hard disk drive is generally referred as a secondary storage of the computer system. The primary storage is being random access memory. So what are all the data available in the hard disk drive can also be available in the random access memory. So whenever a file or data is stored, certain space on this cluster is allocated to this data. It is called allocated space. So any data which is available in the hard disk can be called as a allocated space. The space on the hard drive which is not allocated for any specific storage or file is called unallocated space or free space. So the moment a hard disk is produced, we have to verify whether how much of allocated space is there or free space is there. It is important to remember that the data which is deleted does not vanish from the system, but gets deleted. But what gets deleted is only to the pointer to the data. The deleted file can be recovered in a forensic tool. These deleted data can remain in an unallocated space till it is overwritten by a new data. So the hard disk will have two important things. One is what is the allocated space, space, and what is the unallocated space. Even if a data in the allocated space is deleted, it will be available in the unallocated space. Next. The simplest way to recover the deleted files is to open the recycle bin and restore the files. Even when the user deletes the files from the recycle bin, they are not lost. It remains on the system unless they are overwritten by other data or the system is physically destroyed. However, there are certain data wiping software which can overwrite on the target sectors with some random data, making the original data to revocable. In such files can also be recovered by using the forensic tools and software like NCAS. In such files can be recovered by using techniques called file curving to trace the files from the unallocated space from the hard drive. So what we must have to realize is that Simply because a file or data is deleted from the hard disk, the court or the investigation agency is not helpless. So a deleted file can be a file available in a hard disk drive can be seen in an allocated space. If it is not available or it was deleted, it can be seen in an unallocated space. If the data are deleted both in the allocated space as well as in the allocated space, it can be retrieved by using the forensic tools. There are some forensic tools through which it can be retrieved. So far as the hard disk drive is concerned, the take home message is hard disk drive is a document. It can be produced before the court. If the document is available in the allocated space, very good. If it is not in the allocated space or deleted, we can see it from the unallocated space. If the data are deleted both in the allocated space as well as unallocated space, we can retrieve it by using the forensic tools. That is the take home message in respect of the HDD. Next. Yes. The next one is important memory system is random access memory. It is the first priority in life forensics or on-scene digital investigations. The reason is all the running process in the system passes only through the RAM. All the running system processes in the system passes only through the RAM. It contains wealth of volatile data that must be taken into consideration. So as I told you that HDD is a secondary storage. But what is primary storage is random access memory. It stores the files that are in use while the computer is running. When the computer is running, all the data are being stored in random access memory. It includes various programs like MS Words, Excel, and other OS. However, we must put in mind that the memory in the RAM is only a temporary storage. For example, if you are working on a document in MS Word, it is temporarily saved on RAM until the user saves it. Therefore, the data available in the RAM is only a temporary storage. The RAM starts fresh each time the computer restarts. Only if the data is saved, it's stored in the HDD. Therefore, what we must understand is the data available in the random access memory is a temporary storage. Only if it is saved, it is stored in the HDD. Next. The another important points to be considered is in case of RAM, the moment power source is removed, the data can be lost. So that if an investigation officer goes to a scene of crime in respect of the offense committed under cyber laws, if the computer is on condition, they will not switch off. Because the moment the power source is removed, the data available in the RAM will be lost. last 5 or 10 minutes, the user may not have saved the data. Since it is not saved, it may not be stored in the HDT. So that most of the investigations, the investigating officers who are going to the scene of crime will not switch off the computer or the power line. Therefore, we must put in mind that the moment power source is removed, the data in the RAM will be lost. However, for getting retrieved of RAM data, live forensic is advised. To access the data, MPDEP 1.0 FTK imager 3.0.0.01433 or Belka Soft Live ROM Capture 1.0 or some of the forensic tools that allows extraction of the entire contents of the computer's volatile memory. In a foreign case, Columbia Picture Industries versus Justin Bunnell, the case arising out of an important cinema, the California court held that a request for RAM is legitimate since the incoming server log data is relevant, where the data stored in ROM qualifies as electronic stored data and therefore it is an electronic evidence. So far as the random access memory is concerned, what is important is that it is only a temporary storage, and the moment it is saved, it will be available in the HDD. Next. Yes. Once the RAM is held to be electronic evidence, the discovery thereof can be sought by using the provisions of Order 11 CPC. You know that any documents, a discovery of the same can be produced under the provisions of CPC. Therefore, even if circumstances may arise, a party may, by using the provisions of Order 11 of CPC in a civil case, can sought for discovery of a RAM as a document. Now the question is, these are all the general details. Now the question is, so what are the electronic evidence which can be traced in random access memory? Random access memory. The evidences such as list of application accessed can be traced. So all the application which are accessed through the computer can be retrieved from the random access memory. In crime scene, if a computer is on, it should not be shut down. If shut down, data logs available in the RAM would be erased. Therefore, it should be taken to sleep mode or hibernate until it is preserved. So the best way of preservation of records in the RAM is, while going to the crime scene, it is to be seen that there should not be a cutoff of power. Once power is shut down, the data logs available in the RAM would be erased. Therefore, before switching off the power, steps should be taken to bring the computer to the sleep mode or hibernate until it is saved. So these are all the general details regarding the random access memory. Next comes read-only memory. Next. Yes. So ROM is a type of computer storage containing permanent data. What we have seen in RAM is only a temporary storage. What is available in read access memory is a permanent data. But what is the salient feature of the ROM is it can only be read, not written to. This is the memory that assists the computer to initiate startup process, which is called booting. When we switch on a computer or a laptop, the computer boots. It is booted simply because the support of read-only memory. So whenever one switches on the computer, it is this memory which will spring into action. Once data is written on ROM chip, it cannot be removed. That is the salient features of this read access memory. Unlike a RAM, which is a temporary storage, read-only memory is having a permanent storage containing permanent data. So what are all the evidences which can be fetched from read-only memory? The evidences such as MAC address, access log files such as browsing logs, system file access logs, device access logs, etc. can be traced. So these are all the digital evidence which can be traced. Now we have to see what is MAC address, MAC address. MAC address means Media Access Control Device. It is a unique identifier number which is used to identify the part of the computer which are primarily assigned by the device manufacturer. So the MAC address is a unique identifying number which has been given by the device manufacturer. Therefore, which device is being used for a crime, or from which device a email was downloaded, the MAC address will be very, very helpful. Similarly, normally MAC address will have 12-digit numbers starting with a 0 and consisting of numbers 0 to 9 letter and letters A to F. It is a unique to each network interface. Depending on the device and operating system, it can be referred as a MAC address, physical address, or Ethernet address. So it may be a MAC address or Ethernet address or physical address in which a unique identifier number will be available, from which we can easily understand which component or device is used for the commission of offense or downloading of any documents. Then, what is browsing logs? Browsing logs information in database which includes the URL that was accessed, the title of the page, time when the page was visited, and the number of times it was accessed. So the log details are very, very important. You could have come across a specific provision under Order 11 Rule 6 CPC. It's a recent amendment with regard to the Commercial Codes Act. Order 11 Rule 6 CPC runs as follows. Any party may seek direction from the court and the court may, of its own motion, issue direction for the submission of further proof of any electronic record, including metadata or logs, before admission of electronic evidence. So, if the court finds that authenticity is a question, or the court may, before admitting any electronic evidence, can seek the log details under Order 11.6 CPC. Therefore, the log details are very, very important. Similarly, the device access logs. The device access logs means name of the device which accessed, date and time of access, source of IP address, etc. How severe the particular access made in the device. So if you have gone to a particular site or a particular file repeatedly, that will also be traced in these device access logs. Then file access log is a list of all requests for individual files, number of visitors and origin of visitors. This file access gives a details as to particular file, how much visitors have visited that particular file, what is the origin of the visitors, who first made the file, and what are all the times in which the files have been seen or have been viewed. So these are all the various data which can be seen from or retrieved from the read-only memory. So as judges, what we have to learn is the RAM is a temporary storage, ROM is a permanent storage. So once the data is written in ROM chip, it cannot be deleted. Next. It's a cache memory. So far we have seen two memories, namely random access memory and read-only memory. The third one is cache memory. It's a process of saving history of access. It's not a storage medium, but it is a very vital for electronic evidence. Where we can see the cache memory? The cache memory is embedded in the CPU of a computer. As you surf internet, the web browser you are using saves tons of information to your computer in the temporary storage. It is called a browser cache or web cache. So in many criminal cases recently, in a Delhi murder case, the browser cache or web cache played a very vital role. Similarly, the evidence such as user visits to web page, such as time of visit, application URL, files downloaded, files printed can be traced. Since cache memory is concerned, the following evidences can be easily retrieved. That is, users visit to web pages, the time of visit, application URL. Say for an example, you can see the High Court website msc.so. This is a application URL. Then files upload, files printed can be taken from this cache memory. Even if the cache memory is cleared by the user, it is possible to recover the same by using the forensic tools. The contents of CPU cache and registers are extremely dynamic and ever changing. So these are all the three memories which we have to put in mind, that there are the three are random access memory, read-only memory, and cache memory, where a lot of details or data can be retrieved. So this is on the part of the hardware. Now we are going to move on to the software. You know very well that software is a set of programs that allows users to perform a well-defined function or some specific tasks. It is responsible to direct all computer-related devices and instructs them regarding what and how the task should be performed. Software is broadly classified into two categories, namely system software and application software. Next. The system software is the software that provides platforms to other software. The most important set of system software programs that manage the computer is called operating system. It is a link between application software and hardware. Operating systems are great reservoirs of the valued information having significant evidentiary value. The system software is a facilitator to capture various logs such as device logs, as already told you, browser logs, which has been explained, files accessing activity logs, network logs into the registry of the respective systems. Next. Then application software. Application software is a software that enables the user to use the computer. It is the end user's program. It includes application like MS Word, MS Excel, database software like MySQL, Oracle, or internet browser like Mozilla Firefox, Google Chrome, and Apple Safari, etc. So from application software, the digital evidence such as activities done in an application program like date and time of access, user profile, list of accessed programs, modification in databases, application logs, etc. can be traced. Next. Next comes the computer network. So computer network means interconnection of computer devices that can exchange data and shares resources with each other. These network devices use a system of rules called communication protocols. There are several kinds of networks, namely personal area network, local area network, metropolitan area network, and wide area network. Next. The picture would show how the networks functions. Personal area network is a computer network for interconnecting electronic devices around an individual. Suppose if you connect your mobile phone via your Bluetooth, it becomes a PAN. PAN involves mobile devices, tablet, and laptop. Then comes land area network. In land area network is a group of computer and all peripheral devices which are connected to smaller areas like room, building, and campus. It is majorly used for sharing resources, files, documents, printers, and other networks across the networks. It will work within 30 meter, 100 meter, 1 kilometer. In LAN, the evidence such as date and time of network logs, access of files from remote computers, printer pool logs can be traced. In the metropolitan area network. The metropolitan area network consists of a computer network across the entire neighborhood. Commercial campus, college, and small geographical region. It is larger than LAN but smaller than WAN. The metropolitan area network, apart from other network logs, the access between the organizations can be traced. So if any offense or any transaction is taking place between two organizations, the metropolitan area network will give more data in respect of that crime or transactions. Then comes WAN, wide area network. It is spread across over larger geographical area. Say for an example, in our course we use Tamil Nadu State WAN, wide area network, TN-SWAN. It's an example for wide area network. In wide area networks, evidences such as date and time of access, IP logs, hacking or intrusion from external hardware network, other attacks such as email phishing attack, access of network servers can be traced. Next. Then comes internet. Internet is also a very important source of digital evidence. When a computer user wishes to use the internet, the request passes through the switch or router, and the computer is then connected to the internet service provider network. Say for an example, BSNL and Airtel are the ISPs, that is internet service provider. So if we wanted to use the internet, first our request passes through the router, and the computer and the service provider will give a connection to the network. The ISP provides service for accessing and using the internet. Through this internet, we can get the following digital evidences, such as browsing logs like date and time of access, website details, financial records, email correspondence, transcript from chat rooms, access to social networking sites, files uploaded and downloaded. So all such records can be traced. Next. You see, these are all the following other forms of electronic evidence. Say for an example, in a digital video camera, we can get the following potential evidence: pictures, videos, files stored locally or on media card. In cell phones, we can get the following digital evidences: text messages, call logs, applications used, social media accounts, address book, appointment calendars, information, documents, email, your email ID passwords, etc. Then from CCTV, we can retrieve the following evidence, namely the videos. In game consoles, we can get pictures, videos, and documents. Next. Wearables like digital watches, we can find the following potential evidence, namely location, applications used, phone book, appointment calendars. In LPR, that is automatic license plate readers, license plate images, pictures of cars, geographical location, metadata. Now, so far as the metadata is concerned, as we know that data, but metadata is data about data. Say for an example, if you can go to MS Word file, where you can make a right click, where you can find a drop down by name properties. Once you click the properties, we can see several details, including when the file is created, the time of usage, and whether any modifications used. So these are all the metadata available in the properties. So metadata is nothing but a data about data. So for in body owned cameras, we can get a potential evidence of videos, and drones, we can get video files. Then electroshock weapons, data files. Next, dongles, identification and authentication information of the card, user profile, level of access, configuration and permissions. Then network interface card and LAN cards. We can get MAC address, IP address, location details. We are using modem, routers, hubs, and switches for having internet connectivity from which all information related to IP address can be retrieved. Similarly, in servers, we can get lost login, mails exchanged, contents downloaded, pages accessed. In network cables and connectors, we can trace which computer is used, the type of devices connected to computer. By seeing the network cable, we can see what are all the devices which are connected to computer. In printer, number of prints last printed, log like date and time, then IP address to trace the device location of a source, cartridge can be considered. Then scanner, we can get the following potential evidence, logs like date and time, list of scan files logs. So far as the copiers are concerned, we can get digital evidence like logs like date and time, data stamps, etc. In CD and DVD, we can get the files and datas. So these are all the several evidence we can get from the computer network, Ethernet connectivity, and all other devices. So with this, I think I have covered the area. But what we have to see is these are all the electronic evidence available in the various devices. The challenge to the judicial officers is how to admit it and prove it. So these are all the two things which the real challenges is faced by the judicial officers in the day in and day out. I think the next speaker will elaborately discuss the admissibility and proof of electronic evidence. So for having given this opportunity, I convey my hearty thanks to the honorable members of the Board of Governors of the State Judicial Academy and the honorable chairman and members of the Computer Committee. Before parting with, I would like to say one thing, that I am not a technical person. I am not a master trainer even. I am after all an end user of a computer system. When a laptop was given in the year 2009 to all judicial officers, except for typing purpose, I never touched the laptops. However, some of our master trainers who are close to me have taught the importance of CIS. We have started to work in CIS where we can get some knowledge. But after coming to this registry, the honorable chairman of our computer committee, under his guidance and staunch support, So we are able to learn something. The tiny knowledge which I had shared so far. So with this, I would like to conclude the session, and the next resource person will take off.
Very kind of you, sir. It's very good opportunity for us to know the basic electronic evidences and the devices what are the data we can get it. Very keen observation of your lecture is given. Very good input for us. On behalf of the Academy and on behalf of the Honorable High Court, we profoundly we made our thanks for your sincere effort to enlighten us. Now it's a time. It's session 2. Mr. Midun Kumar Allu, Advocate Hyderabad, our Madras High Indian Institute of Technologies technocrat, who is an advocate. Now, going to adorn the next session, overview of cyber laws. Sir, it's ready, sir. Please come, sir. Mithun,
Thank you
sir,
very much.
you can start, sir.
Thank you very much for this opportunity. Sir, can you make me a presenter so that I can put my slide deck on?
Yes, sir.
You need to give me permissions as presenter, sir.
Yes, sir. You can present.
Is it visible properly, sir? Are the
Yes,
slides
sir.
visible?
Yes, sir.
Okay. Thank you very much for this very beautiful and great opportunity. So I would specifically talk in 2 sessions. First session, we will be talking about cybercrime, the kinds of cybercrime, and what the current trends are. And in the second session, we will talk about digital evidence, essentially Section 65B and the requisites of the digital evidence, how to be handled once it comes to the court, how it is going to be processed, and how we would decide finally whether that is relevant, not relevant, admissible, and post that how it can be incorporated in coming to a conclusion of some dispute in issue in a civil matter, or whether guilt or innocence in a criminal matter. A basic fact, an interesting fact, about September 2022, roughly the estimate of the world population is about 797 crores. The number of devices which are connected to the internet by that particular period of time is now about 25,000 crores. Now, not every computer, not every device is connected to the internet. There are many devices which are inside. There are computer networks which do activities within the buildings. They are not actively connected to the internet. But we are looking at 25,000 crores of devices. Indian population, we are looking at 141 crores. The devices connected is around 210. Now, this is the estimate before COVID period. Post-COVID period, even children are being provided devices for their education purpose, for their academic and other entertainment purposes also. Families are giving children devices. So there are going to be substantial number of devices which are connected to internet. What is happening now is there are devices which are getting connected to internet, and the brand or the category is a smart devices. The funny part is devices are becoming smart, people are becoming very, very unsmart, if I will say. We have devices like flower pots, where you don't have to ask your neighbor to put some water if you are going on a vacation or if you are leaving town. You can control your flower pot through your phone, and then it will give water to the plant. This is a advertisement which is almost 8-9 years old. This is pretty common advertisement. Many of you would recognize. This is a air condition advertisement. Air condition which has Wi-Fi connection. The advertisement which shows here is that one of the actor says, I am starting from office. I have turned on my AC at home. By the time I go there, it will be very cool. That is the advertisement. Interesting advertisement. We have devices like this. Most of us would know Alexa, Google, Echo. We have these devices. These are devices which would act on voice commands. These are in our homes. These devices continuously listen to our commands. We have cars now which are connected to internet. You can actually turn on the engine in the car through your phone. You can turn on the AC in the car. So let's look at two interesting news items. There is this person who wanted to marry a girl, and when he tried and proposed, their family, the girl's family, did not agree. So what this gentleman did, he went and poured some kerosene or a fuel in the morning in the house, and then he burnt. 2 people died. Let us look at a different news item from a different place. There are 5 people of a family who slept in a room. The air condition was on. There was fire, and then they died. In the first case, it's a clear case of a crime. A person has done an act causing death of another human being, and it's a crime committed. Hence, it's a murder. In the second case, if you see, the fire inspector is responsible, who comes and tells the police the information on where the fire started and if there is any fire accelerant used. That's all. The role of the fire inspector ends there. It is for the police to investigate further. What one needs to see is, with so many devices and home appliances being connected to internet, is this a normal bad maintenance short circuit, or is it a deliberate attempt which caused the short circuit in that particular device? It is no longer a crime where, no longer a situation where people are to be physically present at that location to commit such a crime. So, this AC, is it connected to the internet? If it is connected to the internet, was it remotely operated in such a way that the fire could have been caused? Now, these are the aspects which the police would have to think and investigate. Earlier, a home appliance starting a fire is just a normal crime. Perfect crime, essentially we have 2 kinds. One, a crime which is so ingeniously come up with that it cannot be detected. People would think it's an accident. There is no question of crime. So, short circuit caused remotely of an air conditioner. Perfect way to get away with a crime. The second type of a perfect crime is technicalities. We are not essentially so much worried because technicalities are very minimal in our judicial system in terms of acquittal. The example is, in Germany, there was a theft, DNA was found, but DNA traced back to one of the 2 twin brothers. There are twin brothers. One of them has committed the crime. DNA has been found. In our system, it might not be that difficult a concept for police to use certain methods to find which of these 2 brothers has committed the crime. But under the Western system, it is much more stricter, and they have their own set of rules. So the laws there prohibits police from charging anyone without identifying which of these 2 brothers has committed the crime. We are not looking at those kind of technicalities as such, but what we are looking at is the concept of a perfect crime being committed which cannot be traced by anybody. So I come from a technical background, so I am a technical person. Please feel free to ask any questions in the chat box. If even during the lecture, you don't have to wait till the end of it, and I will be watching the chat window, and we'll be able to answer or incorporate the answer while we are going through. Another aspect, network speeds of internet. This is everyone would be aware. The speed of data transmission or internet speed is measured in this megabits per second or unit of megabits per second or gigabits per second. Bits, 1 byte is 8 bits. So typically, if you are looking at a 1-page PDF document, we are looking at about 150 kilobytes. A long judgment, even if it's in a Word document, maybe about 200 KB on average. In 2018, the speeds on the left-hand side is mobile speed, on the right-hand side is broadband speed. The speed of mobile was 9.14 Mbps download and 3 Mbps upload. And the broadband was 23 Mbps down and 19 Mbps up. That approximately that was the kind of speeds we had in 2018. So it means if anyone were to have accessed any of your cell phones at the beginning of the lecture, by this time, when I started the presentation, by now, your phone is still with you, but the data in that phone, we are looking at least 6,000 to 7,000 documents would have already been taken and copied. We are comfortable because the phone is right next to us. Physically, it is with us. But if somebody were to have connected to your device, by now, substantial data would have been taken back. The significance of this data comes in when we talk about saving of bank information, personal private information, pictures, and maybe some documents or judgments which are not yet pronounced. So essentially, we are looking at a possibility which exists, which is real and which is imminent now. It is just that the accused or the criminal needs to have the means, motive, and time. Just a matter of that. Now, internet speeds have gone even further. Post-COVID, internet, there was huge demand for bandwidth. Substantial internet has been spread. A lot of people have started taking up internet broadband to their homes. And now we have 5G. It cannot be disputed that mobile phones have changed the democracy of the country. Mobile phones have given power to the man even in the most rural places to have his voice heard. And now we have 5G networks coming up. We looked at the broadband speeds of 250, which was like very, very high. It's crazy. But now we are looking at 5G being rolled out. 5G internet at this point, the speeds are hitting 500 megabits per second. 500. The theoretical speed for 5G mobile network is between 1 Gbps and it may go up to 10 Gbps. What exactly does it mean? What exactly does these numbers mean? Many of you would have seen our Netflix or Amazon Prime streaming platform. If you look at it, they have an option that if you wanted to watch the movie offline, you can download the movie onto your device offline, and even if there is no internet, you'll be able to play. If anybody has done that, it takes a lot of time, but now on a 5G network, when fully deployed, it would take 30 seconds for a full movie in high definition to be downloaded onto your device. Now that's substantial speed. So now everything is two-way. So if you can download movie, you can also lose all your data within that period of time also. Data is a two-way street. The issue with cybercrime, the issue with any cybercrime is that the victim is the person who provides the device. Victim is the person who continuously keeps the phone or a device charged. Victim is the person who pays for the internet also. All the accused has to do is take the opportunity, means, and attack and make his mark. Let us look at another scenario in cybercrime. If you closely look at these pictures, do you see something, anything off? They're just pictures. Do you see anything off in these pictures? They just look like some people, just look like normal people. These pictures. Please feel free to use the chat window. None of these persons in these pictures are real people. These are computer generated images. That means no such actual person exists if you search for the whole world. The eyes are from a different person. The eyebrows are from a different person. The skin, the texture, you may find some features. These are artificial intelligence generated pictures. There is a website down there. You please go to the URL. Within a fraction of time, you just refresh your browser, you will get a new picture. Now, this is a technology being used for a positive purpose. They essentially are looking at trying to generate an artificial human being who can be your virtual guide. When you are going to a tourist attraction, they want a virtual person who looks like a proper human being to be able to give you a commentary of the place. Maybe in future, a person who is generated will be used as an actor or an actress. So that is something which is substantially a positive use to make enough money. So that is where the technology is to be used for. But everywhere, whenever there is technology, whenever there is technological growth, people would be able to find a way to misuse it and commit something. So now, if you were to use one of these pictures and try to obtain a fake license or a fake document, in the scene of offense, the accused will leave that to misdirect the police. So once they would go find these proofs, and they will be looking for a person who's never existing in the real world. That is where the technology is at this point. Artificial intelligence. Now, with growth of artificial intelligence, right now we have what we call deep fakes. Deep fakes essentially means if you have a video wherein there is one person, you can take the picture of another person's face and impose it on this particular person's video. So you would have a fake video where you would feel as if someone who has not been in that video is actually the person participating in that video. The same thing can be done for audio also. In case of audio, the person would have never spoken those words, but those words can be used they can be made to be spoken through artificial intelligence. It is absolutely not difficult at all. This is something which can be done with minimal resources. You don't need substantial amount of computers, substantial amount of software or money. All you need is the knowledge of where to find this software. It's also freely available. Software to have deep fake made is freely available. any decent computer. If you have a low configuration computer, it will take a longer time to make that video. But if you have a good computer, you will have better quality video come up and in a shorter period of time. What artificial intelligence is doing at this point is it can be used to even predict a person's reaction or behavior. We are getting to a stage where if the person knows your last 10 passwords, the last 10 username and passwords which you have used for your bank, the 11th, the new password which you are likely to put, that can be guessed. Because if you see, we have our, I'm pretty sure when you are using your passwords, when it expires every period, you are making slight modifications. Initially, you might have made some substantial modification, but over a period of time, you start adding 1 or 2 more characters or adding some sequential items in the front or at the back. So there are certain patterns which can be evolved from artificial intelligence. So it is easy to predict a person's behavior and also guess the passwords. Also, you can understand the person's behavior through artificial intelligence and send a interesting item, fake news item, based on your consumption, and you will be tricked into clicking the same. The moment you click on the phone, it is possible to put some software onto your phone by hacking and then take the control over that electronic device. What's more is now artificial intelligence is at a situation and an advanced level where it can imitate the writing style and the style of chatting also. So what's going to happen is it's possible to impersonate another person by understanding his previous chats. And then through artificial intelligence, you can actually impersonate him and send chats to other people and then commit crime. Money is not just the only aspect which can come in front and back. It is possible. Deepfakes have been used for positive purpose or negative purpose. They have February 2020, we had Delhi Assembly elections where Manoj Tiwari of BJP, his deepfake was used for a political purpose. Now there is a conflict on whether it was a positive use or a negative use, whether the opposition used it or BJP used it. The question is, in politics, the videos have started being used. What happened is, in this particular video, to reach various electorates, to reach people from the rural areas of various states, Mr. Manoj Tiwari's voice was used in different accent by a mimicry artist, and lip sync was also added by using a deep fake, so that when someone in the rural area sees the video, he'll be able to connect to the person as his own local person. So that's essentially an impact on the electoral process. What is possible is it can be used positively to connect to people. A person who does not speak Hindi can actually campaign in Hindi speaking areas. A person who doesn't speak Tamil can campaign in Tamil speaking areas using this technology and reaching out to the voters in WhatsApp or any other social media platform through his videos. So he would speak as if he is speaking in native Tamil, and maybe the Tamil flavor in Chennai will be different from Tamil flavor in Madurai, and you can have all these which can be done by the same candidate to make himself more attractive. Now that's a positive use. A negative use is also possible. The content can be manipulated and a statement which is not made by that person can be inserted. This might be done by the opposition parties, and this person's credit will take a serious beating. Not only that, it can be used to create communal tension also. So it all depends upon the creativity and the time the criminal puts in, and the tools are just right available. You just need, the criminals would definitely need some long-term planning and vision, and that is something which criminals are getting better at. Deep fake porn. Now, this is definitely going to be one of the things which would come up more often. Now that the tools of making deep fake are becoming more and more easier to obtain, and data speeds being very high, revenge porn, essentially what happens is to harass, humiliate some person, a revenge to take revenge for whatever the accused perceives to be something which has gone bad against him. What he would do is he would collect the pictures of the victim and impose it on some particular pornographic material, and then the victim would be humiliated and serious psychological harm would ensue. Psychologically, there is enough research in psychological journals that the impact of deepfake porn on the teenage victims is substantially higher, and it may lead to severe mental health issues. On top of it, the situation of mental health system in India is pretty bad. Can anybody guess the total number of doctors who are mental health experts in India? We are looking at what, 800 crore, 900 crore people. So what would be the total number of mental health doctors in whole of India? Any guess? I don't know. You would be surprised that the total number of mental health doctors is 3,500. 3,500 doctors in whole of the country. So that is how bad the mental health system is. And if people start having so much of trauma, we will not be able to address them in time, and that will lead to lot of crime where one person would cause physical harm to another or physical harm to himself. Now, to address deepfake porn, we don't have any special enactment or any special statute. Under our existing law, at the most we can get 469 or 468 IPC for such a particular activity. There is no IT Act provision per se which will cover deepfake porn. There are, under the Information Technology Act, we have offences under Chapter 9 and Chapter 11. Chapter 9 deals with 43, Section 43, A, B, C, D, E, F till J. There, each of this offence is for one subsection. So let us look at the first Chapter 9 offences set. First, Section 43A, the primary portion of the Act or this section is if any person without the permission of the owner or any other person who is in charge of a computer system or computer network. Please note that in IT Act or in Evidence Act, the word computer means any electronic device. It is computer network, computer system, and any electronic device. So just whenever you read the word computer, just imagine that it is any electronic device. So any person without the owner or the in charge of computer, meaning administrator of that electronic device, secures access to such computer, is committing the offense under Section 43A. These are all definition sections. 43A, B, C, D, and so on are definition sections. The first portion which you are seeing here, the first word which I have written down, this is something which I have put. IT Act, Information Technology Act, does not define these words. These words are for our understanding. Information Technology Act just says Section 43, these are the acts. If you do this act, this is the punishment. There is no definition of this. For our convenience, I have put in this. Section 43A is hacking, which is unauthorized access of any electronic device. Now, even though it says if any person without the permission of owner or the administrator, that doesn't mean that the owner or administrator only can give a complaint, because the concept of locus standi is not applicable in criminal law except in few exceptions. For example, matrimonial cases or defamation cases where there are specific people who need to approach the specific forum. Section 43A does not prescribe punishment. Section 66 of Information Technology Act defines, prescribes the punishment. If any person dishonestly or fraudulently does any act referred in under Section 43, he shall be punishable with an imprisonment for a term of up to 3 years and a fine which may extend up to 5 lakhs or both. So Section 66 is just a punishment prescribing section. The most common mistake or most common way of filing an FIR is the police would file Section 66 of IT Act. But Section 66 talks about any of the offenses in Section 43. Section 43 has a large set of offenses which are distinct. For example, Section 43A is hacking. That means if you are using someone else's or authorizing someone else's computer, you're accessing without authorization someone else's electronic device. Section 43B is data theft. Hacking is 43A, which is completely different from data theft. Data theft is where somebody without the permission of the owner or the administrator downloads any data or copies any data or extracts any data from the computer. So the proper form of filing an FIR is Section 43, whichever be the offense, A, B, C, D, E, F, read with Section 66 of Information Technology Act. Or the way they do it in North India, Section 66 read with Section 43, A, B, C, or any of the offenses. It doesn't make any difference as far as my knowledge goes. If I am wrong, please do correct me. For me, I mean, as far as I know, in the FIR, it doesn't really matter if you put the definition section read with punishing section or the punishing section read with the definition section. I don't know the difference as such, but I believe there is none. But please do correct me if I am mistaken. Section 43C is spreading of virus or contaminant. That means if somebody spreads virus in some computer network, then he is punishable under Section 43C read with Section 66 of Information Technology Act. 43A is hacking, 43B is data theft, 43C is spreading of virus. Each of these subsections, each of these are a distinct offense. The ingredients are different. The whole act itself is different. Section 43D is damage. So any person who causes damage to any computer, any electronic device, essentially, he comes under Section 43D. Now here, the explanation gives what damage is. Damage means destroy, alter, delete, add, modify, or rearrange any computer resource. Section 43E is disruption. Any person who disrupts the functioning of a computer. Now, the word disrupt is not defined in IT Act. So we need to take the simpler straight meaning or the dictionary meaning, which means prevent the normal operation of the computer or electronic device. Section 43F deals with denial of service. Denial of service means those people who want to use the computer with their login and password, they are not able to log on to that computer and use the service. So for example, if you overload the railway reservation system in the morning period where these Tatkal tickets are to be done, you overload the system, then people who are authorized, people who already have logins, they will not be able to use and make a booking. Not all, there might be few people who are not able to make a booking. So denial of service could be limited or it would be complete, but denial of service essentially means a person who is authorized and supposed to access the computer is not able to access the computer resource. Section 43F covers that. Section 43G deals with abatement of hacking. Any person who provides assistance to access a computer without authorization essentially falls under abatement of hacking. Section 43H. This is theft of services. What it means is if one person is using someone else's account and password and uses a service and the bill is sent to the other person. So essentially we are looking at, let's say, Geo Internet at this point. Geo Internet has, you use a login and password, any internet service provider, they provide you some amount of data and then there is a difference in the quality of service. And then if you want again some more data, you purchase that. Suppose I use your login and password and consume such a service, the bill is actually paid by you, then it comes under theft of services. Now this will get more interesting. What if the consumption does not lead to bill? Meaning, suppose I use your Netflix login and password. You have your login and password. I do it. Netflix permits multiple persons to use the login and password. The bill is still the same. Will I still come under section 43H? Here, the charges of the services availed of by a person should be billed to another person. Everyone is aware criminal law has to be interpreted strictly. So in such a case, if there is no bill, that means if it is an unlimited subscription program, would it still come under theft of services? Will it come under hacking? Absolutely yes. Because unauthorized use of the resource, section 43A would come, but would 43H come? Kindly have a look. Section 43I, this is information damage. This is very close to section 43D. Here it says, this any person without permission of the owner or administrator destroys, deletes or alters any information. Now section 2O defines data as a representation of information. So essentially information, if you cause damage, if you cause harm to the information, essentially you are causing harm to data also. So 43D and 43I are extremely close. So at this point, whenever there is a case of this nature, it doesn't make substantial difference because the punishment is the same, the fine is the same, and hence the section doesn't make a huge impact in terms of the small nuance of data being a larger set of information. Section 43J, theft of source code. Whoever steals source code or alters the source code would come under this section. Section 43A to section 43J. These are chapter 9 offenses. There is also a civil remedy for these actions. Essentially, if somebody does not do any of this dishonestly or fraudulently, in such a case, civil liability will still come up. For civil liability, it is the IT Act prescribes that this particular this particular wrongs would be done, adjudicated by an adjudicating officer who is the secretary of the Information Technology Department. So insofar as judicial officers are concerned, if the claim is less than 5 crores, there is no role of civil courts insofar as IT Act is concerned for compensation for failure to protect data or taking some data out where there is no, if it is not a crime. The civil liability is what I'm talking about. The adjudicating officer would be the Secretary of Information Technology Department. The claim, if it is more than 5 crores, it would vest in the regular civil courts. There is a procedure prescribed for approaching the adjudicating officer and there's some fees for it. insofar as the notification is concerned, insofar as central government resources are concerned, it is Secretary of Department of Information Technology in Union Territories. And in case of states, it is Information Technology Department, the Secretary of Information Technology in the state department. There is an appeal process which goes to the adjudicating officer, and then there is a second appeal which goes to the High Court. The slides are going to be, I have already sent it to the resource, I have sent it to the coordinator, so you will have the complete set of the slides available with you. Cyber stalking is essentially one of the cyber crime, but it is actually listed in section 354D of IPC. It is not under the IT Act. Section 354D stalking, the first portion is a man who, subsection 1 deals where subsection 1 para 1 follows a woman, attempts to contact such woman and tries to foster personal interaction despite a clear indication of disinterest by such woman. The first part is stalking in physical form in real world. The second form is cyber stalking, where a person monitors the use of a woman of the internet, her email, or any other form of electronic communication, that is social media. Now, then a man is said to have committed stalking. If you see, cyber stalking only by a man is punishable under section 354D of IPC. If a woman stalks another woman, she would not fall under section 354D. This is not gender neutral. Section 354D is not gender neutral. POCSO covers children. So there, the gender of the child does not matter. So section 11, if you see, section 11, we will talk about a child. And there, the child gender does not matter. But insofar as adults are concerned, 354D, stalking is only a woman, accused can be a man. We will soon see complications where we are trying to identify third gender. Now, when the third gender role comes in, transgender persons come in, their rights are recognized. Then, if crimes are committed by such a transgender person, which category would we fall? If the crime is against such a transgender person who identifies as a woman, would that person be falling under this? There was one case which has come before the Delhi High Court, but nothing substantial has come. Conclusive answer has not come as to what would happen to a transgender person and where would they fit as a victim, as an accused also. Now here, for the first conviction, it's up to 3 years imprisonment, and for subsequent conviction, it is 5 years imprisonment and fine. This is chapter 9 offences, which is 43 ABCD. This is where we cover the first set of offences. Chapter 11 deals with a different set of offences. Section 65 deals with tampering with computer source documents. We have theft of source code, which we have dealt with in chapter 9. Here we are looking at section 65, tampering with computer source documents. Section 66A has been held unconstitutional. So it's no longer in the statute book and no cases should be booked in this particular offense. This was held unconstitutional in Shreya Singhal versus Union of India, landmark judgment, wherein the Supreme Court has come and said that if a criminal law is not clear, that can be a ground to hold it unconstitutional. Clear in the sense which can be clearly understood by the person what is prohibited. Ambiguity should not be there in criminal law. That is one of the most important principles which has come up out of the many principles which have come in the particular matter. Section 66B, punishment for dishonestly receiving a computer resource. Now, somebody receives a stolen laptop, stolen iPad, stolen electronic device, stolen phone, which is common. These days, electronic devices are stolen, somebody is receiving it. Punishment for dishonestly receiving a stolen computer resource. The punishment is up to 3 years and a fine which may extend up to 1 lakh. You may see that dishonestly receiving stolen property under 411 of IPC. Same punishment, except the difference is fine. In case of IT Act offences, the fine amount is substantially higher than in IPC offences. IPC offences, we talk about fine in a range of thousands. In IT Act, the fine for these punishments is in terms of lakhs. Another problem which the police face, or what they do, is whenever there is a receipt of stolen computer resource, the law says when there is a special law and a general law, special law would prevail. So technically, for receiving stolen laptop or a stolen phone, the offense with which the accused should be charged is section 66B, because this is the special law. But the offense will be charged under 411 IPC only because police do not want the inspector to be investigating the crime. All the offenses in the Information Technology Act are required to be investigated by a person of a minimum rank of inspector. So for that reason, this is happening where to enable that the sub-inspector level persons to investigate, they are charging in this section. So we need to see if there is a challenge which is mounted on such a thing, that that the offense should have been section 66B and the investigating officer is improper. No matter has come, as far as my knowledge goes, to any high court on this aspect. It is an interesting aspect to be seen when it comes to one of the high courts. Section 66C, punishment for identity theft. Whoever fraudulently or dishonestly uses the unique feature or electronic signature, password, he is said to have committed the offense of identity theft. Section 66C. Most common is creating fake profiles of persons, trying to pass off with their profile pictures, display pictures. Those kind of offenses will come under section 66C. Section 66D, punishment for cheating by personation using a computer resource. Similarly, whoever uses a computer resource to cheat by personation, in such a case, is punishable under section 66D. Now, compare the punishment for cheating by personation in IPC. Same 419 IPC. The imprisonment, the term of imprisonment is 3 years, but the fine amount, here it is 1 lakh, there it is in thousands. Section 66E is punishment for violation of privacy. Whoever intentionally or knowingly captures, publishes, or transmits image of a private area of a person, without his or her consent, under circumstances violating the privacy of that person. Section 66E compares to voyeurism in section 354 IPC, but section 66E is a gender neutral law. 354C IPC, only a man is punishable. The victim can be only woman. But section 66E, the victim can be a man also. So any image of private area of any person without his or her consent. So section 66E is punishment for violation of privacy, and it's a gender neutral law. In Kerala, 2014, there was this government hospital where doctors captured delivery of triplets on a phone, and this video was shared in their WhatsApp group, the doctor's WhatsApp group. This video went viral. Once this happened, the patient, essentially the patient gave consent for operation, but the patient did not give consent for videography. This is a delivery of triplets, which was a complicated and it was medically an interesting case. So then this particular case was booked. Section 66E is for violation of privacy, and section 67. Section 67 again, obscene content. We will talk a little more in detail. Later, when it went to the bail petition, things changed, and then since these offences were less than 7 years and 3 years imprisonment is the punishment, then the anticipatory bail was not essentially given, it was dismissed. I am not sure as to what happened later, but the essential crux of the matter is that anywhere there is a possibility, police generally put the offence of section 67 obscene. Section 66F is the only offence which has substantial punishment in IT Act. Section 66F is punishment for cyber terrorism. To understand it in a simple fashion, whoever with an intent to threaten the unity, integrity, security, or sovereignty of India does the following actions, which is denial of service or hacking, introduction of virus, or he goes into restricted computer systems, meaning defense systems, utilities which are defined as protected or restricted systems, and uses that to cause damage or injury to the nation, he would be punishable under section 66F. The punishment for cyber terrorism is life imprisonment extending up to life. I have not seen a section 66 FIR till date. Section 66F, I mean cyber terrorism FIR till date, but that provision is there, it is possible. Now, section 67, punishment for publishing or transmitting obscene material. Now, this is the most abused section now because of various factors on the police. Section 66A used to be abused because of various pressures. After section 66A is held unconstitutional, the most common section being put in an FIR is section 67. Punishment for obscene. Whoever publishes or transmits or causes to be published or transmitted in electronic form any material which is lascivious or appeals to the prurient interest, or if its effect is to tend to deprave and corrupt the persons who are likely to have such a result in the circumstances, essentially. So section 67 deals with obscene content. Now, first conviction is up to 3 years, subsequent conviction up to 5 years with prescribed fine. Now, what is obscenity? What is the test of obscenity? We will just spend a couple of minutes on test what is obscenity and what is test of obscenity. The first time the question of obscenity came up in relation to a Hindi film. This was a 1978 film where there was a lot of revealing dresses, there was a French kiss between the lead actor and actress, there was a lot of implicit nudity. Now this movie, it was challenged. In the censor board, the producer of the film gave a speech. Essentially, he said, in a country where Mahatma Gandhi is born, you have no problem with persons standing with guns. The hero or the villain with a lot of blood on them, and such a posters are stuck on many walls. You don't have a problem. All I have shown is some form of nudity of a woman. You seem to say it's a problem. Somehow, the censor board was convinced. They gave him a certificate. The matter went to Supreme Court, where it was tried to be shown that this movie was obscene. What Supreme Court held, Supreme Court took a technical stance. It said, as the censor board has already given a certificate, they have given a certificate that it is for certain type of audience, certain type of age, certain age plus audience. Where is a question of obscenity, and we are not going to adjudicate whether this is obscene or not, because section 79 deals with it or exonerates him. So the prosecution was quashed by the Supreme Court. The next time the question of obscenity came up in a substantial level is in the year 1993. Now, the left side, there is a magazine where sports person Boris Becker, he is from Germany. This was the German magazine. There, just like the caste system, the ethnicity of a person would make a huge difference. So a white person marrying somebody from the African origin or a darker skinned person was a huge issue. So he married this particular lady, and since it was a different race, interracial love affair and a marriage, it was a huge issue. So his interview was published, wherein he talks about love has no color and stuff like that. So that was a German interview. The same interview translated in English was published in India in Sports World magazine, and the same picture was used in the cover page. In 93, one person had filed a private complaint, a criminal case was booked, where summons were issued to the accused, the editor of the magazine. In 1993, they filed a discharge petition also, that this is something which is not obscene. The reason being, logically, the German magazine is still being sold in India. It is not banned. There is no problem with that. The English version of it is being called as obscene. It is not at all obscene. The discharge was not allowed. The discharge petition was dismissed by the magistrate. The matter went to High Court. By 17th, it went to High Court in 2004. By the time High Court came, High Court heard the matter. The marriage of these persons collapsed and they divorced also by 2004. By 2001, they had actually divorced. The matter came in 2004 for quash. High Court did not quash the petition, did not quash the offense. Then the matter went to Supreme Court 10 years later, 2014. Here, Supreme Court said, we have to apply the community standard test, not the Hickling test, where what is obscenity. Community standard test. In what is the current community standard? A picture of a woman as such cannot be called obscene unless it has certain tendencies of sexual in nature. One needs to look at the context in which the particular image or artwork is to be seen. Obscenity has to be judged from the point of view of an average person by applying the contemporary community standards. The standards of the community have changed from a different context. We have to examine the obscenity around the context. You can't just take the picture out of context and say it is obscene. Okay, what was the context? So this particular man wanted to talk about love. He wanted to talk about being blind to racial differences. Hence, he was sending a message there. Hence, the criminal case was quashed. So, as of 2014, what we need to look at is what is obscene has to be tested on the contemporary community standard. We will take a short break in our video. I will try to speed up a little. I'm actually behind. And thank you very much, Mr. Prakash. What I've been told is a Mumbai Sessions Court has convicted a person under cyber terrorism. I will actually try to find if I can get the material to in this regard. This is October 2014 case. Prakash sir, thank you very much. So I will try
It's time for break. For 15 minutes from 11:30 to 11:45.
Okay.
Please assemble in time. Thank you. Thank you, sir.
Is the presentation visible? Thank you.
Good afternoon, friends. It's time. Please join. Please all mute the mic for seamless connectivity and for understanding. If any questions, please put in the chat box. Sir, Madan Kumar, sir.
Thank you.
Sir, you can start, sir. Thank you, sir. Thank you.
So we looked at Avik Sarkar from the state of West Bengal. So that is where the Supreme Court held we have to apply contemporary community standards for any piece of material which is thought to be considered as obscene. In 2018, another matter came up in Kerala High Court. What happened is there was a magazine published in Kerala wherein the context was that women are not breastfeeding their children due to lack of privacy if they are working. So working women essentially are having difficulties. In that context, this particular magazine had published this cover page. This was thought to be arraigned as publishing obscene material. Here, fortunately, within 8 days, the matter came up for quash. And in this particular judgment, 3 steps are set. 1, on an average person's view, if we are applying the contemporary community standard, would the work be taken to appeal to the prurient interest? 2, does the work depict or describe specified sexual act in a patently offensive manner? 3, does the work lack serious literary, artistic, political, or scientific value? So put these tests, and then it was found this particular picture was not obscene, and the prosecution was quashed. This the New York Institute, the Costume Institute, conducts this program every year, where they have different themes of dresses. One Indian actress has put on that dress, and somebody morphed the picture with the Chief Minister of West Bengal's face on it. Now that picture, somebody else had morphed it. That picture was shared on social media by one of the persons, and this particular person was sought to be arraigned, and immediately Cybercrime Police Station had booked a crime in Calcutta under offences of Section 500 IPC, defamation FIR, and Section 67 and 66 and 67A. See, the person was arrested and surprisingly was remanded also for this particular picture. The content which was posted by this particular person is this. this particular picture is not created by her. She reacted to this picture with such a emoji. She was arrested, and then the matter went up. Her brother was at the Supreme Court, so the matter was, a writ petition was filed before the Supreme Court. On 13th May, it was dropped. The prosecution was dropped as mistake of fact, but she was not released until 14th May, the next day, when Supreme Court has granted immediate release on bail. A contempt has been filed and it is pending. So what happens essentially is there is substantial pressure on the police to file an FIR, and that is where they are using this section 67A as the recourse. One more popular case, is where another actress, she wrote material stating that the father of Prime Minister, former Prime Minister the Jawaharlal Nehru, he was a Muslim and that he had 5 wives, and there was a lot of misinformation. She had stated, he had claimed that it was a Muslim person name. Here, a particular person had filed a complaint. Again, the FIR was booked under section 66D and 67. Later, the very next day, once people started making noise, the charges were altered to section 67 and 504 and 505. He was released on bail the very next day, but there is substantial pressure on the police to use this section or use some section to essentially book an FIR. The matter of fact is, whatever the lady has stated was not in these books. What she stated is definitely an inaccurate information. At the most would fall under defamation. And in case of defamation, it is the legal heirs who are affected, the person who is affected, or the legal heirs who are to approach the Honorable Court for their redressal, the concerned jurisdictional magistrate for the redressal. Section 292 of IPC deals with sale of obscene books. We are looking at transmission of obscene material in electronic form in IT Act. Section 292 of IPC deals only with papers, books, pamphlets, drawings, writings, paintings, and figures and objects. Similar punishment, there are exceptions for it. The first, the exception being bona fide religious purpose or ancient monuments and temples. The same thing applies to IT Act obscenity also. Section 67A, punishment for publishing or transmitting material containing sexually explicit acts. Section 67B, punishment for publishing or transmitting of material depicting children in a sexually explicit act. Now here, there are multiple portions in this act, in this particular offense. Kindly look at the grooming part. There is, if anybody cultivates, entices, or induces children to online relationship with one or more children on sexually explicit act, that will come under section 67B. The grooming of children for sexual offenses is essentially split in multiple portions because of the way the section is drafted. If the grooming is to have sexual relations with other children, it comes under section 67B of the Information Technology Act. If the grooming is for the purpose of pornographic use, the offense would come under POCSO. If you may kindly see the difference in the offense as such. If the grooming is for sexual activity with children, it would come under 67B. If the grooming is in relation to, or enticement is in relation to, for the purpose of pornographic purpose, section 11(6) of POCSO Act. There are exceptions to section 67, 67A, and 67B, which I have said, like historical. This is something which is historical. This is a Warren Silver Cup. It's a historical object. It has a man having sexual intercourse with a boy. Now, this actually would come under POCSO Act, but since it's a historical object, it would not. Temples, religious purpose. These are it depicts explicit sexual activity is depicted, but this object is on a temple and it is exempted under ancient monuments. The question is, in case of cartoons where there is no real victim, if there are cartoons made where a child is shown having sexual intercourse, or the cartoon which depicts a underage person or a child having sexual intercourse, would that come under section 67B? The position of law of virtual images of minors. There is a US case where they have said that any visual depiction, irrespective of whether that particular cartoon is a real person or it's a fake person or a non-existent person, it will definitely come under the mischief, and hence we should interpret that under their law that it has to be seen as a child, because it doesn't say real child or a human child. It comes under the definition of child. No challenge before Indian courts, from what I know. Please correct me, or if there is any, please do let me know if any of them has come, where a cartoon is treated as a child, and hence section 67B is applicable to publishing of material which is cartoons also with a child. Section 77A of IT Act deals with compounding of offences. Compounding is permitted except in the cases of socioeconomic offences, or against a child or a woman. IT Act offences cannot be compounded if it is against a child or a woman or a socioeconomic offence. All the offences are cognizable, and those offences which are punishable with imprisonment of 3 years are bailable. Earlier, at least in the past 3-4 years, there was a lot of difficulty. Most of the voice service providers, no longer people are using exclusively regular phone calls only. People are using apps for phone calls, WhatsApp calls, Telegram calls. They are using multiple messengers for these providers. These providers work on they are headquartered in a different country, and they have a different law or legal requirements. What they do is, as much as possible, they try to stick to the US or UK standards where they are headquartered. So what is happening is, the difference between these the rule of law requirements across the world is that we have 91 CRPC, which is commonly used. 91, 92, 93 CRPC deal with 3 different aspects, but 91 CRPC is most commonly used, where if you look at 91 CRPC, whenever any court or any officer in charge of a police station considers the production of any document necessary for certain purpose, the court issues a summons and the officer issues a written order. 91 CRPC police officers issuing to different providers within India, they are complying. But those outside India, they do not comply to 91 CRPC orders from police because they don't have an equivalent in their country. So what they need to do is they approach the courts, the concerned magistrate court, make an application and get a summons issued, which is actually complied with. What the Western countries, the companies which work in their domain, they do not want any liability. If there is a court order, they would comply with the court order happily. So the idea here is, under 91 CRPC, they do not have an equivalent of police officer giving a written order to get them information. But they would recognize, out of the jurisdiction of India, they would recognize any court summons which calls for some information or document. So 91 CRPC through the court summons would be something which will be acceptable for handling these kinds of cases. The courts need to be more liberal for in granting the such a summons to the investigating officer during the process of investigation. In the legal system of India and United States, we have a little difference. We deal with prima facie case, there they would deal with probable cause. Probable cause is a little higher standard than a prima facie case. That's essentially where it is. And the request should have some sufficiency of material. And if the details are clear, there will be cooperation with the investigating agency here by the organizations which are outside the jurisdiction of India. Under Section 78 of IT Act, no officer below the rank of inspector shall investigate the offences. Another aspect is, can a passport be seized? Passport cannot be impounded by the police or by the court. There is a specific provision for it, specific rule for it. Passport Act is a special act and it would override the provisions of CRPC. So in cybercrime offences, essentially imposing a condition that bail, as a bail condition, passport is deposited will go a long way in ensuring the presence of the accused in cybercrime offences to face the trial, and then whatever be the result, that is up to the court to decide based on the evidence placed before it. Suresh Nanda versus Central CBI talks about the power of impounding not being present with court or the police, but it leaves it very open that as a condition for bail, passport imposition has not been dealt with. So Suresh Nanda versus CBI clearly talks only about not to impound passports either by the police or court. Only as a condition of bail, it is permissible. Now, electronic evidence. Do you have any questions on the first part on cyber laws? If not, we will go look at electronic evidence and the procedural requirements. Okay, I will start off. Section 65, Section 65A and Section 65B deal with electronic evidence of Indian Evidence Act, Section 65A and Section 65B. Section 65A says the contents of electronic records may be proved in accordance with provisions of Section 65B. If you follow the provisions of Section 65B, electronic records can be proved. Now, Section 65B, admissibility of electronic records. Again, please remember, the word computer means any electronic device. The whole computer network, computer storage, all that, everything comes down to electronic device. It's easier to go through. What does it say? Notwithstanding anything contained in this act, if the conditions mentioned in this section are satisfied, computer output shall be admissible in evidence as original, and any fact stated in the output is admissible if direct evidence relating to the same is admissible. What does it mean? Section 65B has certain conditions and certain requirements. If those conditions are satisfied, computer output shall be admissible as if the original is produced. So the first thing one needs to observe is that if I produce the original electronic device in the court, the moment I produce the electronic device in the court, the question of Section 65B does not arise legally. Now we will look at practical aspects later, but legally, the requirement of Section 65B comes when an output, computer output is sought to be shown. So basically, you are taking a printout of a document or a printout of an image. Now that particular printout you are trying to use as electronic evidence, then section 65B, that means that printout should be accompanied by section 65B. In section 65B, what are the conditions? What are the requirements? Four conditions. First condition, the computer was being used by the person who has lawful control over it. What essentially it means is the computer from which you are extracting and printing out or taking the data on a pen drive must have been in control, lawful control of a person. Suppose the particular computer is stolen and recovered, and then you want to recover the data. There is a possibility that during this process, where the computer was in the custody of unlawful person, a person who had unlawfully obtained it might have tampered with it. That is the logic. So the computer must have been in a lawful control in the ordinary course. First condition. Condition number 2. The computer was used in the ordinary course to generate the output which has been produced. That means you have to use the main computer, not the computer connected to it as a backup or a backup of that. The point here is you need to use the main computer wherever the data is. And then generally in the IT industry, it's a common standard to make backups. So when you take backups of data, you need to make sure that the data is properly backed up. So for that reason, section 65B requires that the computer was ordinarily used to generate that output which has been produced. There is no transformation in between. That is essentially what the condition number 2 is. Condition number 3, that the computer was working properly when the computer output was generated. That means the person taking that should be in a position to tell that the computer is working properly. He need not be expert, he need not have PhDs on it, but he should have sufficient working knowledge that he can say, yes, computer, these conditions satisfied. Computer, fourth condition, the computer output is a proper reproduction or derived from the information in the ordinary course. Meaning, after generating the output, somebody who is issuing such a section 65B requirement, we call it the certificate, must have checked, okay, yes, what is visually seen is what has been printed. Yes, the computer output is a proper reproduction. So, section 65B requires 4 conditions. There are 4 requirements also, meaning required details also. First requirement, the manner in which the computer output was produced. So for example, if I am taking a CCTV footage, how did you extract the CCTV footage? I am giving that, yes, CCTV is working properly, the computer was, the CCTV, the DVR was in the control of the person who was supposed to have a control, it is in the ordinary course, it is being used, and I have extracted that video footage onto this pen drive and the video is matching. 4 conditions, okay. Requirement 1, how did you do that? I went to the OEM software, original equipment manufacturer software, so and so, selected that timeline, extracted it, pasted it on the pen drive. That is the manner in which the computer output is produced. Section 65B should state that also the particulars of the device involved in the production of the output, meaning what was the device name, what was the device model, what was the printer make, what was the model. If possible, serial number also, so that it can be identified properly. Particulars of the device involved in the production of the output. Third detail, the name, details of the person who is responsible, who is in a responsible official position in relation to operation of the device or management of the device. 4, the matter should be stated to the best of knowledge and belief. The point here is, if somebody were to give a false certificate, he is punishable under 197 of IPC. So the certificate should have been given complying with these 4 conditions. and 4 requirements. If it turns out to be false, they'll be punishable under 197 of IPC. Who can provide Section 65B certificate? Any person who can make a copy and is in lawful control of the computer from which the output is being generated, that person can give. Number 2, this person need not have expertise, but he should have sufficient working knowledge. He should have clear-cut working knowledge. So when you ask a question, the court expects the person to give, okay, what was the model before? What is the next model which is coming into the market? How does this particular device, what are the options available? Because the CCTV technician need not know Fourier transforms or how the video is encoded or what kind of video encoding is possible. That is not his job. That is not what we are looking at. Experts are required to say how are these digital videos encoded, how are these digital videos decoded. That is a different situation. Insofar as accepting some electronic data as evidence, Section 65B requires a working knowledge person who can answer these 4 conditions and 4 requirements. 4 requirements are to be provided and the 4 conditions must be satisfied. How does this person say that the computer is working properly, the DVR is working properly? Does he have enough qualification to do so? He need not be a computer science PhD person or an expert to say whether the DVR is working fine or not. DVR or NVR. DVR, now with network video recorders, NVRs are the new models. But does he have sufficient knowledge? That is what is important. Who can provide certificate? He need not be expert, but he should have sufficient knowledge, sufficient working knowledge to satisfy the requirements of Section 65B. Any question related to the condition of the computer or the details how it has been done, he must be able to provide. Is there a specific format for Section 65B certificate? There is no prescribed format. Maharashtra and few states, Maharashtra, Delhi, they are giving some template to the police officers, but Section 65B can be in any format. Bombay High Court said even if it's in the form of affidavit, it is acceptable. But what is recommended is I, so and so, with particular details, hereby certify that this particular data is, and then you give the 4 conditions and provide the 4 required details. That would be a comprehensive and a complete Section 65B certificate. In the Telugu states, certified copies of revenue documents are also being given digitally. And behind those, this particular Section 65B certificate is being given. The law behind it. The law behind Section 65B certificate took a small change and detour. So let's start with Anwar versus Bashir. Anwar versus Bashir was a pre-judgment judgment wherein Section 65B, being a special provision in relation to electronic record, prescribed that Section 65B certificate is mandatory in case of electronic evidence. Now let me go back to Section 65B, the first portion. If the conditions mentioned in this section are satisfied, computer output shall be admissible as evidence as original. So if I were to produce the original device, I don't have to. But if I produce an output, that is when I have to give Section 65B certificate. So Anwar versus Bashir clearly said that being a special law, the general law of Section 63-65 does not apply. Secondary evidence rule. You have to follow whatever is prescribed for in Section 65B, and electronic record by way of secondary evidence shall not be admitted unless the requirements in Section 65B are satisfied. Now there was confusion came in 2018 where in Shafi Muhammad, they said some exceptions are there. If the device is not in the hands of party producing evidence, Section 65A and B are not complete code. that was held, but that has been corrected. In 2019, the matter was referred to a larger bench because of the difference of opinion, and Arjun Pandit Rao Khotkar, which is 2023 SCC 216. This is where Shafi Muhammad has been overruled, and Anwar versus Bashir is held to be the correct law, wherein Section 65B certificate is mandatory. The question comes, when can we produce a Section 65B certificate? When is it to be given? Now let us understand why is Section 65B worded so. Let us look at that. It says computer output can be used as original. What is special about electronic evidence that we are able to give? What is so special about electronic evidence that we are okay with a copy or essentially a clone? Let's say I'm giving you a hypothetical example. Let's say there is a hospital. There one particular person or a business person should not be given some medicine. Accused comes while this gentleman is in hospital, gives that medicine in a syringe, gives it to the saline bottle, drops it and leaves, and the person is dead. This is a clear case of murder. Here, the syringe which is used will be part of the material objects seized. Suppose the same murder is done in a modern hospital by inserting digitally the same medicine on the prescription, so that the night duty nurse looks at the prescription and gives the medicine, and still the victim dies. This is also murder. In these two cases, when we are looking at physical objects which are produced as evidence, we do not permit any replacement. We don't permit any copies. But electronic evidence, Section 65B, we permit a copy. What is special about this? The speciality of electronic evidence is that you can make an exact replica, bit by bit, exact replica by using cloning method, and the original remains intact. It is not damaged. So for that reason, electronic evidence is treated differently. That is the reason why Section 65B provides for computer output to be treated as if the original has been treated. But of course, you have to follow these 4 conditions and 4 requirements. When can we give that? In Sonu versus State of Haryana, 2017 8 SCC 570, Section 65B certificate was not filed in the trial. In the appeal, objection was taken that Section 65B was not filed, and hence the call data records in that particular case should not be used against the accused. The court said prospectively it will apply. You cannot raise the question of Section 65B not being filed, this procedural aspect in appeal. That is what the court held. But as of now, during trial, Section 65B is absolutely compulsory. So what does the impact of that? When an electronic data or record is to be shown or marked as evidence on that particular day, the court requires a Section 65B certificate. If Section 65B certificate is present, only then you would mark this digital pen drive or whatever digital data which has been produced before the court as evidence. Otherwise, you will not mark the document at all. Or you may mark it as identification, but you cannot mark it as evidence, because without Section 65B, you cannot look into any electronic evidence. That is the position of law. Now the question comes, when should this Section 65B certificate be filed? Section 65B certificate, the crucial time or the most end time where it can be filed is before the witness gets into the witness box, tries to mark this document, the document which is the electronic document. So the question is if Section 65B is not filed at the time of charge sheet, can a subsequent Section 65B certificate be filed? Sure, but the person producing that Section 65B certificate must be in a position to satisfy those 4 conditions and 4 requirements. That means the original person who has extracted the data, the original person who has put on that original device, only that person is entitled to give Section 65B certificate. Somebody new cannot say that whatever has been filed in the court is correct. That is essentially giving false certificate. A person who has actually done it, who has that knowledge of how it is done, that person can give the certificate. He can, the practical way of doing it is immediately after collection of electronic evidence, they should, immediately the investigating officer should take the certificate then and there. If that is not possible, before filing charge sheet. If that does not happen, just before the witness enters the witness box to mark these electronic devices, then he should be able to produce the Section 65B certificate. But the point is, just because it is produced late, that doesn't mean it is not valid. But you need to ensure that Section 65B conditions are met, meaning the person giving that certificate should be able to say that this copy is a correct copy. That means the person who has actually done it, maybe 2 years ago, 3 years ago, 4 years ago, doesn't really matter how long ago, it should be the same person. And the device also should be identified. What has happened in one matter is the CD has the signature of the person who has given the certificate. The person who gave the certificate is also still available, but Section 65B is misplaced or it's not found in the file. At the time of charge sheet, can a person take the Section 65B certificate? Sure. If that same person is present, he tells and he checks, yes, this hash value is matching what was taken in that hash value, and this is my signature, so I can give this certificate. There are some questions which have come. When electronic evidence was already marked 7 years ago, is it mandatory to insist on production of Section 65B certificate at present? If it is already marked, but the position of law has changed, judgment has not been passed, what has been done is only marking. The appreciation of evidence is only possible if you comply with Section 65B being mandatory, because these 3 changes have happened. Initially, Section 65B was held to be mandatory. After Shafi Muhammad, it said no, not necessary. Once Pandit Rao, with the new Pandit Rao court judgment in 2020, we have had, yes, it is compulsory. So in this process, it is possible that some particular electronic evidence would have been marked. But to admit it and appreciate that, we definitely need Section 65B certificate now. How will you get it? The person who has given has to bring. If not, the courts are bound not to look into that particular evidence because the mandatory provision of Section 65B is not complied with. Another question is that in civil cases, some party files along with the plaintiff some photos. Is it necessary to obtain Section 65B certificate now? Now, photos 15 or 10 years ago, 15 years ago, if you are talking about 15 years ago, I am not sure if it's actually a digital photograph. It could be a film photograph, but assuming for a moment, if it is a digital photograph, definitely Section 65B certificate is compulsory. They can file a Section 65B certificate now, but they need to ensure that for that particular picture, all the data is present. What I see is that when we have photographs, there is something called EXIF metadata. EXIF metadata, just like what was covered in the first class. If you look at a Word document, right click on it and look at properties, you will see a lot of details as to author, modified date, content. Similarly for pictures, if you may check even your photograph in your phones. If you have taken a picture in your phone, you go to that particular picture in gallery and then look at info. It will contain the camera name, aperture, what was the shutter speed, what was f-stop, what was the ISO value, and you will have the resolution, the date, and the time on which it was taken. So this is that EXIF metadata. If that data is present, That means that's a picture which is taken directly from the electronic device and it has not been modified. If anybody uses Photoshop or any other image manipulation program, this data gets automatically modified with that particular software name.
Sir, Mr. Midhukumar, sir,
Sir.
Ms. Inia has raised a question as to whether digital evidence marked before 7 years, can it be the certificate under section 65B is necessary. There is a direct authority on this point. Union of India versus CDR Ravindra Desai. Union of India versus CDR Ravindra Desai, 2018 lawsuits SC-358. 2018 lawsuits Supreme Court 358, where it has been held that non-production of a certificate under section 65B at an earlier stage is not fatal. It is a curable defect. It is a curable defect which can be made cured.
Sorry. It was a curable defect until Arjun Pandit Rao Kotkar. That is the problem.
What do you say, sir?
This particular position of law in 2018, this curable defect aspect is not going to hold post 2020 because of the judgment of Arjun Pandit Rao Kotkar. The new judgment. This position was in 2018, we were in the Shafi Muhammad period. Now 2020, Arjun Pandit Rao Kotkar has come, where strict compliance of section 65B is compulsory. Now we are at a
now her question is whether it can be produced at a later stage. Whether
yes, yes, absolutely.
Question is whether certificate can be produced at a later stage, because 7 years back it was not produced. So while so, this citation will definitely squarely applicable.
Correct. Thank you. Another interesting aspect, in the earliest occasion in 2004, it turns out that in state of Tamil Nadu versus Suhas Katti, it's a trial court judgment where the accused impersonated a woman and posted obscene messages in Yahoo groups. At that point of time, 2004, Yahoo groups was very, very popular. There, he gave a posting, and the complainant got so many calls from strangers soliciting sexual services. Now, accused was convicted under 469 and 509 of IPC and section 67 of Information Technology Act. The judgment copy, in that particular judgment, you will see that section 65B certificate of the complainant was accepted, wherein the delay in filing that section 65B certificate also, it was not filed at the time of charge sheet. The delayed filing was also accepted, and the text which was the position which has been done, section 65B of Evidence Act does not suggest that the certificate should be issued by an expert. It is enough if the person issuing the certificate was to have his best of his knowledge and belief, and he was in management of the relevant activity or the device. The point here is the person who is giving section 65B certificate should be competent and knowledgeable enough. If you ask questions on how you have produced it, how you have documented it, how you have extracted it. Insofar as the cyber experts are concerned, section 79A of IT Act, there they have central government notifies the examiner of electronic evidence. Even though the act came so long ago, the notification insofar as section 79A experts are concerned, they are done in the year 2018. Directorate of Forensic, these are the different labs where the experts of electronic evidence, government labs, experts of electronic evidence are present. Any of these people can be called, but that does not mean that non-government experts are not permissible. The law of experts being permitted in the courtroom remains the same, whether the expert is in information technology sector or any other sector. Section 293 of Criminal Procedure Code gives some special benefit to reports of certain government experts. Any document by these experts can be marked without the expert being cross-examined. The court may permit if there is an application made that such an expert should be examined by one of the parties. So these persons are the chief examiner or assistant chemical examiner, or the chief controller of explosives, the director of Afghan Institute, the serologist of the government. These are the persons who are exempted from appearing, but their report can be marked. There is no exemption for electronic evidence as on today. There is no electronic expert who comes under the 293 of CRPC. The last option is any other government scientific expert specified by notification. Electronic evidence wise, there is nobody who has been done so. There is one more question. What is the scope of criminal liability on a person who deletes a picture which was taken with consent in another person's device without the consent of this person for reason like privacy? Two parts. When the picture was taken, there was consent, and hence the picture was legitimately and legally taken by the person in his device. First part is over. Second part, now they have some dispute, but the picture is still the property of the person in whose device the picture is. But due to privacy, now that the consent has been revoked, he cannot publish it, transmit it, but he can keep it in his device. At the most, he can keep it. Now the question will be, it will be very uncomfortable. Basically, what happens is, I think there is a US case where wife and husband had taken consensual pictures, and after divorce, the wife wanted those pictures to be returned. The husband said, those were best memories of my life also during the period of my marriage. Just because the marriage is ending now, I don't want to give. So I mean, the essential, there are two conflicting reasons, and then I believe the matter was settled or there was something which was done. So the point, insofar as the position of law is concerned, there are two distinct things. If after the withdrawal of consent he commits any other act than keeping that picture on his phone, he will become criminally liable. But holding that phone or keeping that picture which is in his custody, I don't believe he's committing any mistake. Now, if the person, the victim goes, takes the phone, snatches and deletes the image, now definitely the person, it is definitely the property of the person holding the phone. It would be a very difficult question, but legally and strictly speaking, it is punishable. What can be done? I mean, law, justice, and morality are three different things. So we go back to jurisprudence. So I will leave it to the presiding officer to handle this troublesome situation. Maybe our registrar can jump in on this with his experience. Law says the picture which is taken in my phone with consent is my property, because I have possession, I have lawful control, I am the one who has taken it, so I am copyright holder also. But the victim, the other party whose private picture is in my phone, comes and deletes it because she or he assumes that this picture may be published. Not published, no intention. This person said, I have no intention, I am keeping it. That is part of my memory. So should the victim be punished for damage of information under Section 43I of Information Technology Act? I hope it's not a real case, madam, but sir, you tell me. I mean, legally, strictly speaking, definitely punishable. That is what the law says. Because a person has caused damage to information on a computer device. That information may be her photo, but she is not the copyright holder or the owner, because the device belongs to somebody else. What can be done? Should she be punished? Yes or no? Maybe. So you tell me, sir, what would you do? Is this a real case, madam? The question was asked. Is this a real case? Are we facing any? Is it a real trial which is going on, or is it a question? Just a thought. So maybe what I would do in these circumstances is maybe convict and under Probation of Offenders Act. I will acquit under Probation of Offenders Act, because the damage which has been caused is not so substantial. Maybe a nominal compensation, if at all the victim, the person who lost the photograph, were to make a lot of noise based on the circumstances, maybe nominal compensation, maybe. Guidelines, the preservation of electronic evidence. Now this part, technically, you may kindly see there are guidelines for preservation of electronic evidence by the High Court of Karnataka in this particular judgment, Madhukara versus State of Karnataka. There, what they have given is they have given certain guidelines. First, all the persons involved should take proper precautions during search, seizure, packing, labeling, and sending the evidence to expert or to the court. Most common physical safety measures is an anti-static bag, so that the electronic device, be it pen drive or any device, stays for a longer period. The second part is the investigating agency has to make efforts to disable the security settings like the PIN, password, pattern lock, or fingerprint before seizing the device. Now here we have Article 20, Para 2. Whether an accused can be compelled to give his fingerprint on his phone, and then that data is used against him. Now this will be a question. I mean, Karnataka High Court has taken one stance that it is permissible, but we have to see when it goes and the law is settled. Maybe someone can help me out here. The investigating agency is asked to make efforts. It doesn't say that you must mandatorily do so. 3, the media containing electronic record should be in a sealed and secured manner to the court, and a copy needs to be kept in with the police custody. The media which is preserved in this case should be done in a proper physically clean and sustainable method, which is anti-static envelope. And after production of the court has to take care of the proper custody. It has to be ensured that the media should not get damaged due to packing or sustaining scratches. The biggest problem right now we face is compact discs are believed to be reliable, but they are not reliable. Not only scratches, it is possible that they lose quality and we will not be able to retrieve information. Compact disc, CDs, not DVDs or archival DVDs. CDs are different. DVDs have much more density. So DVDs and archival DVDs are possible. There are some DVDs which come with a gold plating, gold color plating, and these DVDs are called archival DVDs. They stay for a longer period, provided there is no physical scratches and damage. So one needs to take care of that part. Then they have to take, and the directions were to have a proper training. And the copy of this electronic record must be saved in the computer hard disk of the police station and also in the consent court. Generally, a folder structure is recommended. What is happening is when we look at our steno computers or the computers with the officers, we are not maintaining, or it is not a standard practice to maintain folder structure. Meaning year, case-wise, material, judgment, those kind of structure is not maintained, but it is recommended that you maintain a folder structure, multi-levels, so that it is easy to organize and also to take backup. Second and very important aspect in terms of saving information on computer, apart from folder structure, do not save any such information on C drive or the partition in which the operating system is installed. You have C drive, D drive, and you have multiple drives which are made. So always save it in a partition where the operating system is not installed. That way, if the computer were to be updated or upgraded, only the operating system gets upgraded, but your data remains intact. Your data remains safe and intact. And that can be also backed up. Backing up of the whole operating system does not make any sense. Any backup software does not do that unless you specifically do so. So for that reason, always maintain C drive, and desktop is never the place to save information. Desktop documents are saved in C drive under a user path. That is not the safest way. Desktop is only for convenience. Please use shortcut feature. You may create a shortcut on the desktop to open the folder in different partitions. Have it in D drive or E drive. You link it, then you can use it easily. But if saving on the desktop is the most dangerous thing you can do. As soon as the electronic record is admitted in evidence, the copy of the relevant portion should be stored in the consent folder in the case and also in separate media, so that till the end of the trial, this does not get corrupted. And the electronic media shall be kept in a safe deposit with the chief ministerial officer I believe, officer of the court, with a direction to preserve it in a proper manner till the case is logically concluded. And experts at FSL also to have a copy if possible, and extract the data with evidentiary value to properly label it. The problem with FSL extraction, they have FSL labs, they have a lot of cases coming in and they do not have a proper filing system. So what is the practical thing? What they do is they take copy and send the copy back. Their analysis and an extra copy also, they send it back to the investigating officer with markings, or the court, whichever is the requesting agency. The FSL people send it off. They say that it is not possible, but the direction says if possible, to have or retain a copy of the document. So insofar as preservation is concerned, so let me tell you the problems with it. One, if you have an electronic device which is given in custody of the court, cell phone is the best example. Generally, from the date of crime till the date of charge sheet, we are looking at approximately a year, unless some cases they might file charge sheet earlier, but at least a year. From the time the charge sheet is filed till the trial is concluded, we are looking at least 3 to 4 years. Unless again, depends on, in exceptional cases, it might be done earlier. So in this period of time, a properly functioning cell phone, if it were to be placed as evidence in the court, the battery would not survive that long. So the battery can swell and you might lose the device also, because when the battery swells and then if there is some leakage, the device itself will get spoiled. So for that reason, even what I recommend is, even if the original device is produced, it is always better to make a copy, take computer output in the form of printouts, and have a Section 65B certificate. That is what I advise the police also. Because when you are filing the original device, the law says Section 65B is not compulsory because you are producing the original. So when you are producing the original, you will not give a Section 65B and you will not make a copy. Then what is going to happen is, if you lose the device, you are essentially losing the whole of evidence. Second thing, the court will not have enough manpower or training to keep all these devices maintained. by charging. One aspect. Two, while charging or maintaining them, how to make sure that they are not tampered. That's another problem. So for these practical reasons, securing the devices is one, physical securing and physical maintenance is one problem. So it's always advisable to ask the investigating officer to print copies with Section 65B certificate so that if the device is not recoverable, we will be able to fall back on the computer output with Section 65B. Second aspect is CCTV footages. There are right now various companies producing CCTV equipment. When you extract the CCTV, it comes in some video format. I advise the police to make sure that along with that video, the video player also be copied onto the pen drive. So that when this pen drive is produced, there should not be any problem decoding it or playing it on the computer, because in 4 or 5 years, that particular player might have become outdated or the format might not be available. Those kind of things are possible. This is what is called as bit rot, meaning the file formats will get changed. In such a case, you need to ensure that the playing software, the video playing software or the audio playing software is also available. Another problem is with electronic devices. It is settled position now that electronic records are also documents. So the accused is also supposed to get a copy of those documents. So when copies are being filed with electronic evidence, the accused copy will also have the digital copy. Now this will have a financial impact on the police, but while charge sheet is filed, this may be something which the court officer must check, that is the accused copy of paper and accused copy of digital evidence is also available. The problem with this particular aspect is digital data. As of now, as on 2022, the best method is pen drive with hash value. How do we generate hash value? Hash value is generated by using a hash calculating software. So you run that software, you put the pen drive, of that particular pen drive image, you take a hash value. So this particular software like HashCalc, for example, is a simple software. You use that software and then it will give you a hash value of that particular file or image, and then you ensure that yes, this data is intact as long as you have the hash value matching. Let me show you problem with Section 65B certificate. The most common thing is we are looking at called data records. CDRs which were produced by the nodal officer. I am actually going to show you a real 65B certificate filed by Geo Internet, Geo. This is the certificate produced. This is the common certificate being produced by nodal officer. Can somebody, I mean, is this text clear or should I zoom more? There are too many problems with the Section 65B certificate. Number one, the signature is done saying nodal officer, state nodal officer or alternate state nodal officer and signature with a stamp of nodal officer. Section 65B has 4 conditions and 4 requirements. What is one of the requirements? Name, description of the person who is giving it. From whole of the Section 65B certificate, where is the name of the person who has given it? Name and identifiable particulars. Who is this person who has given Section 65B certificate? A just nodal officer is just a designation. Nodal officer is not a person. It is just a post. Section 65B is given by a person, not a post. So that particular person, name and details are to be available. Number 2, the 4 conditions which are required under section 65B are given. They just copy pasted it. But have they given the details which are required, which is the manner in which the output was generated? They write only one point. This has been generated by computer system of the company. They give the best of my knowledge, true to the best of my knowledge and belief. That belief is dropped. There is no my belief. Best of my knowledge and belief. Best of my knowledge, full stop. This is a template being followed. We've been trying to tell the investigating officers to send a template to them so that they can give. So requirement of particulars of details, who they are, what it is they do. Second is what was the system, what was the make, model, how it was used, and then the particular best of knowledge and belief. What I have seen, one of the best things I have seen is from Google. I will just, this is the circular of issued by, are you able to see the circular? Circular issued by the additional DGP of Tamil Nadu. Here, they give an example of one certificate by somebody from Google. Now here, they give it in proper format or proper details. There is no prescribed format, they give that. Here, I so-and-so, I am the legal so-and-so person. They give all the details. I am the records custodian. I am employed with this company. This is where I am. I have the authorization and I can submit on the behalf of, I have personal knowledge of these facts. And then she says that this particular email is so-and-so. And she also mentions, this is a little bad. She also mentions the computer which is used, the printer which is used to produce the output. So this is a complete and a comprehensive Section 65B certificate. It's a very...
Sir, Mithun sir.
Sir.
Sir, this similar question is also raised by Mr. K. Ananthan Subjudge, author. Is there any prescribed form or format to file a certificate under 65B? If not so, what kind of formula or requirement to be adopted? So regarding the model format of Section 65B of the Indian Evidence Act, a direct judgment on this point, which gives a prescribed format of Section 65B certificate. AKR Shipping Company Limited, AKR Shipping Company Limited versus CRT Shipment Management Private Limited, 2007 SEC Online Bombay 663, 2007 SEC Online Bombay 663, wherein a detailed format regarding the format of Section 65B is given, sir. I think that will serve the purpose.
Okay.
Okay.
Statutorily, there is no prescribed format, but as long as it complies with the 4 conditions, 4 requirements,
yes,
you can use.
yes.
Bombay, Maharashtra is giving one format, sir. Delhi is also giving one format.
Okay.
As long as these are there,
I think we can have some lead.
Yes, absolutely.
Because some of the police officials may not have formulated all the legal requirements in a specific format. Since it is a format given in by a court in a judgment, I think it can be used for our purpose.
Yes, sir, absolutely. Yes. Next. Section 167, this is one aspect which has been coming to my mind. Section 167 CRPC, whenever an accused is produced for remand, is he entitled to the documents which are produced by the investigating officer to be held against him? Why he is seeking remand? Insofar as the Telugu states are concerned, we had adopted the Madras Criminal Rules of Practice, but they have been modified later. So here, under the criminal rules of practice, what we have is that when accused is produced for remand or extension of remand, all the material which the person, the police inspector relies upon should be produced or given to him so that he can effectively represent before the court whether he should be further remanded or not. I have been told that this is not so in Tamil Nadu, so somebody may throw light, but if it is so, if at any stage, insofar as trial is concerned, before when the accused appears, production of documents have to be given to the accused. All the documents which are going to be held against the accused need to be given to the must be given to the accused. This includes any digital or physical evidence. So all the statements, LW statements, whatever be the documents which are produced by the inspector against the accused, along with the digital data also, a copy must be provided to the accused.
Sir, I think one Ms. Sankita Segar has also raised a similar question. How can electronic evidence be given to an accused under section 207? Okay. So for that, your answer will apply, sir.
And I will tell the judgment also, sir. Our Suresh Gopi case of Kerala.
Yes, sir.
Dilip, I think his actual name is Dilip. Yes.
Sir, regarding the copies under section 207, digital copies under section 207, one leading judgment on this point is Manu Sharma versus State NCT of Delhi. Manu Sharma versus State NCT of Delhi, 2010 6 SEC page 1. 2010 6 SEC page 1. This judgment has detailedly explained section 207, 243 and 91 CRPC along with the copies, furnishing of copies of digital records. The position is what you have said, sir, but only for academic aspect.
Yes, sir. This also, please.
Okay.
Chips, photograph chips, video chips are also document. This one also, P. Gopalakrishnan versus State of Kerala. This one also, 2019 SCC Online, Supreme Court 1532. Both, this one also deals with the same aspect. Another question which is quite common is Google satellite images. Are they electronic? I mean, can they be accepted as evidence, or can they be accepted as evidence or not? Kindly see relevance and reliability. These are two things which are different. An evidence is relevant if the court feels that the fact in issue has some relationship with this evidence. The relevance is different. In few cases, Google satellite images are filed by parties to the proceedings. There, what they do is, this particular image is extracted, or satellite photograph is extracted, and section 65B certificate is taken, and then place it in the court. Here, accepting or admitting is done if the compliance of section 65B is done. After that, appreciation of the evidence is very specific on a case-to-case basis. The law is clear on section 65B. Once you have section 65B compliance, this particular evidence comes into the trial. After that, how it sways, which party gets what, is something which is specific to case. It is not that we have to take it as granted, or that we have to say this is not valid. It is not so. That is appreciation of evidence. Is different from admitting and marking of the digital evidence.
Sir, regarding the admissibility of satellite sketch, I wanted to refer one citation for our judges. VS Lad and Sons. VS Lad and Sons versus State of Karnataka. VS Lad and Sons versus State of Karnataka, 2009 Criminal Law Journal 3760. 2009 Criminal Law Journal, page 3760. In this case, the Honorable Karnataka High Court has held that a satellite sketch is admissible in evidence. For two purposes, the satellite sketch have been relied on. One, to find out the location of the accused. Secondly, to identify the spot of the incident. For these two purposes, the satellite sketches were admitted into evidence.
So there is a question, at the time of marking of a document, whether electronic device can be marked without Section 65B certificate in negotiable instruments cases. Evidence Act, as long as it's applicable, proceedings does not make a difference. Be it civil, criminal, check bounce case, murder case, I mean, the trial form, whether it's a summary trial or whether it's a regular trial or whether it's a sessions trial, those are all different procedural aspects. But insofar as Evidence Act is concerned, Section 65B is compulsory for any electronic evidence, irrespective of the proceedings, except I guess in family proceedings where they are making exception from Evidence Act. If you see in section 2 of Family Courts Act, Family Courts Act says something of family proceedings. Karuna sir, am I right on the spot on that? Family courts, except for family courts, wherever Evidence Act is compulsory.
Yes, sir. Section 14 of the Family Court Act. Section 14 of the Family Court Act.
Next question, whether CCTV footage of private buildings will affect a person's right to privacy. Right to privacy, of course, you cannot have a camera which will zoom on to the opposite person's bathroom. If you're in an apartment complex, you have another person's apartment right there and you're trying to
Sir, excuse me, regarding the family matters, one judgment, Pramod EK versus Launa VC. Pramod VK versus Launa VC. This is not the judgment of our Honorable High Court, but it's a judgment from Kerala High Court. AR 2019 Kerala, AR 2019 Kerala 85, equivalent 2019 SEC Online Kerala 165. This judgment is somewhat different because it says a strict rule of Section 65B may not be imported for family court proceedings.
That's what, sir. Family court has exceptions. Yes. Only yes. Family court has exceptions.
However, the judgment gives certain cautions. It cannot be take it as granted. The judgment gives certain cautions. The judges may, since a paucity of time, judges may read it later. Okay, you proceed, sir.
The investigating officer got cell number from Airtel company through email. The cell phone number is also marked as exhibit. Does it require a certificate? The investigating officer got the cell phone number from Airtel through email. The cell phone number is to be marked as an exhibit as it requires a certificate. The question is a little not clear, sir. Please, if you can rephrase, that will be helpful. I'm not able to understand. I'll go to the next question. Defective 65B certificate is produced. The 4 conditions are not complied. What is the evidentiary value? It was marked in terms of Bipin Chandra Panchal, I guess. If a Section 65B certificate is defective and it can be cured by having a Section 65B certificate in a proper compliance of Section 65B, and the person giving it is the same, I think that should be possible, as we have already covered it before. Evidentiary value is after the same, after what has been admitted, then you would look at the evidentiary value. Either you admit or you don't admit. Once you admit, then you would apply the regular principles of relevance and how it plays on the issues at hand.
Sir, one question from Combined Court Buildings, Dindigul. When a digital photograph is marked during the cross-examination and admitted by the party, okay, whether the party making the photograph to be insisted to produce a certificate under Section 65B of the Evidence Act?
Looking at our judgment, any electronic evidence, we have come to a stage where it is strict. But what is happening is the party is admitting in the cross-examination, the other party is admitting the contents. This makes it complicated. Whether the party marking the photograph be insisted to produce the Section 65B certificate, since it's electronic evidence.
The direct answer is given by our Honorable High Court in case of Shyamala Ranjini versus Tamil Alagan. See, AR 2008 Madras 476. AR 2008 Madras 476.
2008. So there it would have been compulsory, correct, sir?
Yes, sir.
2008 compulsory. 2018 to 20 not compulsory. From 2020 it is back to be compulsory.
During cross-examination, this point deals about cross-examination. Even if it is admitted, Section 65B of the Indian Evidence Act is necessary.
Sir, where are you taking the citation from? A bag or something? You have some magical bag, I think. I am giving the answer, you are taking a citation out and giving out. Where is that? In civil cases, whether computer downloaded certified copies of sale deed, birth and death certificate, marriage certificate presented, would it require Section 65B? Civil criminal is not the relevant portion, madam. If it is computer downloaded from a computer from source, for example, in Telugu states, Revenue Department puts up the certified copies of sale deeds or documents online. If a person pays the prescribed fee, he is able to download that particular document, and it has a digital signature also. If you click on it, it will get a green tick, just like our High Court and Supreme Court judgments. When you download, the digital signature will be there, where you will get a green tick. So such certified copies are definitely, they come under electronic evidence. You definitely have Section 65B certificate. You say that, yes, I downloaded from this website and I have checked that the certificate is, the signature is valid, and that will be admissible. But marriage certificates, I have not seen being put up online. So marriage certificate and birth and death certificate, unless the department puts it online with a digital signature, if you produce it from your computer with a scan, no, that cannot be permissible with Section 65B, because the original document is with you. You are scanning it in your computer. You are printing it on your computer, and you are saying, I will give 65B certificate. Now that, because one of the four conditions is not satisfied, that the computer output should be generated from the computer, where in the ordinary course, that is what is being done. Meaning, the marriage certificate is not being produced or generated by that registrar of births and deaths computer. This is a computer of the user. Hence, one of the conditions of Section 65B openly will not be satisfied. Under these circumstances, even if they produce a Section 65B certificate, we have to say, how is that condition satisfied?
So similarly, sir, one judge, Mr. Shaktivel, has raised a question whether a computerized chitta and adangal requires to mark as exhibit in civil cases. So far as this aspect is concerned, our state of Tamil Nadu has issued a circular stating that if there is online patta and chitta can be used as a evidence, provided the court can check it up with the QR code available in the such records and mark the same. Okay, that GO can be followed. So if any chitta or patta is produced by a party and it has a QR code, the court by using the cell phone or some other instrument, check it, the QR code, and ascertain the authenticity and originality, then it can mark a document. And the factum of verification of QR code may also be put in the notes paper. That is very important. There is a circular which will we will send it to the concerned courts. You proceed, sir.
I'm just looking at the questions. What is the procedure? Excellent question, sir. When certain exhibit is marked in some rent matter, a qualified engineer inspects the property for demolition and files a report along with photos and CD. If the other side wants certified copy of those, what is the procedure? I am facing a big problem here also. In Telangana also, in Andhra also, how do we give a certified copy of CD? No rules have been made, at least in Telangana High Court or AP High Court. Madras High Court, I am not sure. Registrar sir might be able to help me. Rules for giving digital certified copies, because regular certified copies, you take a copy in Xerox, you stamp it, you sign it, and then you give the CA number, and you are good. But if you are giving a certified copy of CD with a file, you need to mention the hash value in the CD, hash value in the copy given to you, and do it. So far, no rules have been framed in Telangana High Court, or in Bombay High Court also I have not seen. Telangana, Bombay, Andhra, these three courts, no rules. Kerala also I am not sure, but Tamil Nadu, sir, you tell me. What is the procedure for getting certified copy of CD?
I think there is no rule at all. So far, no rule is framed in this regard. To the best of my knowledge, I don't know whether some of our judges may know, but the reality must be taken into consideration. At the end of the day, the court says a CD is a document. Okay, a compact disc is also an electronic record, and it is a document. So nothing prevent the court from giving the a copy of the CD. Okay, a copy of the CD. What best we can do is, whenever any CD is produced for evidence before the court, the CD may be copied in our cloned copy can be given. Cloned copy can be given. There is nothing wrong in it.
Maybe one extra suggestion, sir. Whenever such an engineer is filing, please request for extra copy, so that we are clear that it's exact same copy, same brand, same thing.
Our problem is whenever any CD is produced, normally what our bench clerks will do is they will put it in they will put it in the bundle itself, and they will pin it with the paper. Okay, that practice has to be deprecated, because ultimately once it is, it must be in a cool temperature, or some preservation method must be there, but they will put it simply in the CD. So to avoid that problem, what we can do is, whenever any CD is produced, we can copy it in our office system by using the case number. That will be better practice.
Another question is, who will mark the Section 65B certificate? Section 65B certificate, the maker of Section 65B certificate is the person who can validate the signature. So the question is, who can mark the Section 65B certificate? Section 65B certificate will be given by the maker, and he is the one who is going to identify the devices. He is going to say, yes, this is the duplicate copy, or this is the clone copy I have made. So in his deposition only, First thing is I have produced the Section 65B certificate. That will be done. Then you will start marking the pen drive or any of the digital data which is so. If there is a specific portion of the file that you copy while the trial is going on the concerned folder structure on the computer. Whether when the police files computer printed copies in criminal cases, whether certificates are necessary. When police are filing it, it is recommended that the police give certificate. But you may definitely mark it. I mean, you may definitely point out that when you are filing this charge sheet, where are the Section 65B certificates? But the point is, when it comes to trial, that is when the requirement of Section 65B is. So it depends upon the rules which are governing the checking of charge sheet. If one of the checklists says so, then I think you should be able to. Sir, under the Madras Criminal Rules of Practice, at the time of checking charge sheet, which is filed in the magistrate's court or any trial court, is there a checklist which says Section 65B is compulsory or not? Written it, for example, if there are accused, if there are accused, 10 number of accused and sufficient copies are not produced, then you will written it saying provide sufficient copies for accused. If it is not clear, in such a case you would do so. So my point is, the question here is whether if they file charge sheet, whenever they file the report, can we insist them to file Section 65B?
What do you feel, sir?
My opinion is, sir, trial court judge is, for the kind of adversarial system which we have, trial court judge is not the spokesperson for prosecution. Whatever prosecution has given, if it is complete, he should accept it. If it is not complete, it is not him to point out the loopholes. That is one problem. Second aspect is justice needs to be done. So my opinion is, at the time of filing charge sheet, you would not. When it comes to trial, it is the burden of the police. Then you say you are supposed to do your job, you do your job. That's the best I can come up with, because we cannot have another judicial function on the already burdened magistrate to check this also, make sure that the prosecution is correct. That would be inappropriate in terms of the separation which we have, in my opinion.
Okay.
While submitting printed copies of WhatsApp chat is Section 65B compulsory, absolutely compulsory, Section 65B certificate. But now with WhatsApp, we have serious problem. Earlier, it used to give you the details of when it was received, when it was read also. Let me show you one message. Let me try to see if I can find you one. I'm sharing the screen. I'm just showing my WhatsApp window. What is happening is, WhatsApp used to give this kind of, this is how, what I suggest, or the way we used to file WhatsApp delivery of summons or WhatsApp delivery of notices, is on the left hand side, we will have the details of the person. In the middle, the conversation. On the right hand side, that specific message information, which is delivered date and read date. Suppose the read information is not applicable, in such a case it is read. When you click at that particular person's profile, you have the profile and the phone number. So these two screenshots would constitute the proof, digital proof that some communication was sent. But WhatsApp is changing their system too much these days, so we are not getting that read information also. Even though you get blue ticks, you are not getting the date and time stamp. So until it gets stable, I guess we will have a problem.
Sir, so far as WhatsApp is concerned, the WhatsApp application is installed in a mobile phone. Okay. WhatsApp application is installed in a mobile phone. Admittedly, a mobile phone is a computer. Okay, mobile phone is a computer. Once it is termed as a computer, any printouts, messages taken in the form of a printout, a certificate under section 65B of the Evidence Act is necessary. So what I feel is, if any WhatsApp communication in the form of a printout is given, the court can insist for the certificate under section 65B of the Indian Evidence Act. Okay.
Yes,
Whether WhatsApp is an admissible document or not is dealt with by the Supreme Court in Suomoto Writ Application C, number 2/20, dated 10/7/2020. Suomoto Writ Application C number 2/2020, dated 10/7/2020, wherein WhatsApp is held to be admissible in evidence. Okay. Now the question, another question arises in another case, Aryan Shah Rukh Khan versus Union of India. It's a famous case, Aryan Shah Rukh Khan versus Union of India, ADBS application number 2571 of 2021, dated 2010-2021, wherein though mobile phone is a computer, the printout is also taken as a computer output. And also it requires certificate under 65 of the Indian Evidence Act. If such certificate is produced at the time of investigation, court need not insist for certificate at that time. Okay. If a WhatsApp message, if printout is filed along with a charge sheet, at that time the court need not insist for
Okay.
certificate.
Only at the trial.
Yes.
So I guess that answers the question in the earlier question, that at the time of charge should we do it or not.
Yeah. Sir, one more judgment I wanted to tell to our judges, whether what is the legal effect of emoji? We are sending several emojis in our WhatsApp. Am I correct? What is the evidentiary value of it? It's a judgment given by our Madras High Court in the case of Linga Bhaskar and others. Linga Bhaskar and others versus state. Linga Bhaskar and others versus state. 2018 4 Law Weekly, page 175. 2018 4 Law Weekly, page 175. In this case, a emoji was put in a WhatsApp group. Different people expressed different meanings.
We can pass on to next question, sir. Sir Mithun, sir.
Sir, yes, sir.
Yes.
Can an accused be acquitted merely on a technical ground when corroborative evidence are available? Mere non-issuance of certificate under section 65A taking away the whole trial. Sir, the law is clear. If there is no certificate, that particular evidence is gone. If there is sufficient evidence other than that, if there is some other evidence, the burden is on the particular presiding officer to decide. No one told the job is easy. It is extremely difficult job, and this is an extremely difficult situation. But the law is clear. If section 65B is incorrect, if no section 65B is present, that data is gone. That particular data cannot be used. If you remove that and there is sufficient evidence, then an appropriate decision may be given, either acquitting or convicting the accused. That's essentially what it is. Okay, Rule 25 of Rule 25 of, I believe, criminal rules of practice essentially covers that the officers in charge of a police station forwarding the final report must file in court as many copies of the report and documents, and that means documents includes the CD and other digital devices. So under section 207 of CRPC covered. I haven't seen the criminal rules of practice, but I think I will read it as such.
We are having our separate criminal rules of practice in our state of Tamil Nadu, sir.
I get the point. So
Yes, sir. Yes, sir. Yes, sir. Yes.
Any other questions, sir? I think I covered. If I didn't cover in the chat, can you please post one more time, please?
Sir, one more question from Mr. Sundar Kamesh Marthandan, second ADM Nagarkoil. In case of forwarded messages, how the originator of the message is traced?
Okay, no, this is an investigating kind of a question. Now, I will tell you the part where when we are looking at WhatsApp or Telegram or these kind of applications, if the message is forwarded, I sent a message to somebody and that particular person forwards it, there is no way you can go back unless there is some material within that message which identifies the main person. So if it's a simple text message and it is forwarded, that data is lost. There is no way you can go back. That is the difficulty in what is happening in terms of tracing people when there is spreading of fake news. One aspect. Number two, if photographs are sent in WhatsApp, the EXIF data or the metadata of the images are getting removed and it gets optimized. That cannot be taken as evidence. But if they send it with the actual full resolution photograph, then it is possible. In WhatsApp, if you go and see in any message, if you go to WhatsApp and then you say attach, when you look at the messaging system, you will click on attach. If you attach it from the gallery, then the image will get optimized. If you attach it as a document, the image will not get optimized. I hope, let me see if I can show the demos. Yeah, let me show you this. Same option is available on the mobile version also. I'm using WhatsApp desktop version just for the demonstration purpose. Not the app. I am using the browser WhatsApp web, which is the browser version. So if I'm sending using, this attachment, if I send it from the camera, the picture will get optimized and the data is lost, or the EXIF data is lost. That cannot be used as evidence because it has already been modified. If I go and select the document option, and in that document option, I select the image, then the image is not optimized. It will have the full resolution image with all the metadata of the image. That can be used as evidence.
Sir, what is the position in case of emails? How to identify the originator?
Email, at least we have some reference. Let me show one email. It has something called the MIME header. So let me look at one. Let me open some email. I want to open professional email because this is already on YouTube. So, tab. I'm sharing my web browser. I'm showing my email.
Sir, in between the word, I wanted to express something to our judicial officers. Okay.
Please, please.
The email is a system which works on store and forward method. Email is a system which works in a store and forward method. Normally, if A wanted to send an email to B, Okay, it directly goes, it must have directly go from A to B. Okay, but what actually has taken place is, if B is not on online, what will happen? So it will take some time, or when B comes on online, the message must have stayed somewhere, so that all the service providers are having a separate dedicated email server. Okay, so when we send a forward a mail to another person, before it reaching to another person, the dedicated email server of the service provider takes that message and send it to that person, so that the section 88A of the Indian Evidence Act provides presumption as to the electronic messages. Section 88A. What it says is that if any message is sent by a person, there will be a presumption that the sender will be the originator. Sender will be the originator. But there is no presumption that he is that person who has actually sent the mail. So you proceed, sir.
Sir, Mithun, sir, you can start, sir. Mithun, sir,
Yes, sir.
sir,
So,
you can share, sir.
yeah, so this is one email which I have got in Gmail. So I went to the option and I said show original. Now this is the original message. Okay. This is a summary of the original message, but essentially this is how the actual email is. Here you look carefully, delivered to this email address, received by, what you are seeing is the IP address of the receiving email server. This is the IP address. This is okay, and this is the SMTP ID number, so and so. Then you keep going down, you will see that the sender also has sent. Where did it come from? It was received from this particular IP address by relay.nic.in on so and so, so and so. So this is how you look at the IP addresses where this particular email has gone up and down. So that's the possibility on email. But on a WhatsApp or any private messaging platform, you will not have this trace. You will only have who sent it. If you are able to, if you receive the message from the device, you will only know which computer or which device has sent it. That's about it. I hope that answers the question on the email part.
Sir, is all question completed?
One question: is it safe to rely on WhatsApp chat because we can change the profile photo of another person? What here there has to be a distinction between appreciating the evidence, believing the evidence, and admitting the evidence. WhatsApp chat with section 65B comes into the picture. Now, whether that profile picture actually belongs to that person or not, there needs to be some evidence which will come to it. It is not that just because there is a WhatsApp picture of me on some particular phone number, it is me only. There is a presumption that maybe it is so, but then whether you can presume or not will depend upon the circumstances and depend upon who the burden of proof lies on. Let's say the plaintiff, in a civil case, let's take a civil matter, the plaintiff says that the defendant, he sent an offer and the defendant accepted on WhatsApp, and he produces these WhatsApp screenshots with the defendant's photo and the defendant's number. When he files it, there is a I mean, he asserts that this is the number, this is what it is. The defendant can definitely say this is not my number and somebody else had used the number and my profile. Then the court will decide whether the plaintiff is telling the truth or the defendant is telling the truth based on the evidence, further evidence which is led. If there is another witness who comes and tells that yes, this is the number of the defendant and this is actually the profile picture of the defendant, in such a case, there will be some sufficient material. So we cannot prejudge that yes, WhatsApp can, I mean, anybody can use a different profile picture, but the whole case is not dependent upon a single profile picture. There are circumstances which are surrounding that particular usage. Based on that, the court will take an appropriate opinion in a holistic manner. And hence, the point to answer is yes, even though many things digitally can be modified, we definitely can rely upon them, but not exclusively. Each piece of evidence must be evaluated on its own merits.
Sir, similarly, sir, another question from Ms. Virgin Vista, JM Additional Megla Court, Ramanathapuram, whether spectrographic test to be insisted for audio messages recorded in phone conversations. How its authenticity is to be checked?
I couldn't hear, sir. Can you please repeat the question? The audio broke.
Whether spectrographic test to be insisted for audio messages recorded in phone conversations. How its authenticity is to be checked?
Any audio conversation is an electronic data. It comes into picture. Then the defendant or the accused may say that that audio does not belong to me. It is very much possible. In a criminal matter, the accused was found with his phone and he had cell phone recorder on. So in the phone call, the audio message, there is some incriminating evidence. When such an incriminating evidence is present, what is required is either the voice fingerprint through FSL, as you are asking, or if there is sufficient metadata. There are two ways to prove it, that it is accused's voice. First is getting the FSL report matching the audio with his particular voice and an expert opinion. Second option is, if there is corroborative evidence that accused is the person who is using that phone on that day, accused is the person at that time made the phone call from that phone to another phone, and three, no other person could have had access to that phone and record the same. If these three are proved, without the FSL test, that can be relied upon. So any case will depend upon how and what quality of evidence comes corroborating this electronic evidence. Purely just because there is an audio recording, that cannot be solely relied upon without the surrounding circumstances. So yes, fingerprint is a better option.
Mithun sir, so far as audio recording is concerned, it's nothing but a tape recorded conversation. The law applicable to tape recorded conversation will also applicable to audio recording. Okay, there are two aspects is to be considered. Firstly, how to get a forensic opinion when a voice is denied. How to get a forensic opinion first. Second aspect is how to prove it before the court. Third one is once the voice audio message comes into the court, how to preserve it. Okay, these are all the questions which are resolved even the year 1973. Okay, I wanted to give three citations on these aspects. R.M. Malkani versus State of Maharashtra. R.M. Malkani versus State of Maharashtra. AR 1973, page 157. Second case is Ram Singh versus Colonel Ram Singh, 1986 AR SC page 3. Then Yusuf Ali Ismail Nagri versus State of Maharashtra. Yusuf Ali Ismail Nagri versus State of Maharashtra, 1967 3 SCR page 720. The fourth citation is Sri Ram Reddy versus V.V. Giri. Your state, sir. N. Sri is a Supreme citation from Supreme Court. Sri Ram Reddy versus V.V. Giri, 1971, 1 SCR, page 399. If all these 4 citations are studied together, a complete law or analogy over the law of tape recorded conversation as well as audio messages will be easily dealt with.
Another question has come: if a Twitter page's printout is taken and filed before the court by the opponent to prove a fact, is Section 65B essential? Any screenshot, any digital aspect must be insisted. One thing which we need to make sure is that when a screenshot is taken of Twitter and he is taking a printout, Section 65B says whatever computer output is permissible, etc. But as a matter of prudence, one extra effort can be made that please provide the digital copy to the other side. One practical solution is when two parties are producing two digital things, the best way is ask either party to provide the digital copy to the other party. They will find the faults with it and they will produce a sufficient material before the court, and then we can decide. That is a much easier method rather than the court going into investigating whether this evidence is proper or not. Let both the parties have sufficient opportunity on both the documents. That's essentially the best practical way forward.
Sir, while answering to the earlier the digital patta and other things, I explained the Tamil Nadu government has issued a GO. Once a QR code is fixed or imprinted, by checking the QR code, it can be acted upon, I tell. But one judge from Mr. Chellaya, District Munchikam JM Worthanad, says that since the GO is not a legislative amendment, how come to GO can override legislative requirement by appeal by the apex court? I think it's also to be taken into consideration.
Now, sir, here the question here is the government order is providing a way of verification. It's just a procedure thing. It is not saying that because there is a QR code, go for it. What it is saying is if there is a QR code and the court can check it. If the court can definitely, any person, not only court, any person who has the QR code can check it. That is what the GO says. GO is not, trumping anything more than what is in the Evidence Act. What Evidence Act says, Section 65B is compulsory and this is what it is. And if a person has produced a document which the court can verify digitally that it is the same, then I think it's more than enough.
Sir,
I think
actually,
hypercircular should be sufficient.
Yes, sir. Answer to his question is Section 4 of the IT Act. Section 4 of the IT Act, legal recognition of electronic records. The section says where any law provides that information or any other matter shall be in writing or typewritten or printed form, then notwithstanding anything contained in such law, such requirements shall be deemed to have been satisfied if such information or matter is rendered or made available in the electronic form or accessible so as to usable for subsequent reference. There is a legal recognition for an electronic form.
Yes, sir, but the question here is if the GO said QR is okay, how is that trumping or going over the statute? GO is saying you have a QR code, please verify. That is all the GO is saying, right? It is not saying any document which has a QR code and be checked need not comply with Indian Evidence Act. I don't think that is what the GO is saying. GO says, correct? Am I getting it right? GO is providing QR code for every document. You can verify. How to verify?
Ultimately, this QR code takes to the original document,
which is on the government website where you actually see it.
Yes. However, it is a debatable point, I think. The learned judge has raised a question.
Sir, brothers, sisters, just those who are having more questions can put in the chat box. Question will be answered even. Question will be answered even after the session is over. Please put your question. And also equally, please don't forget to fill the feedback form, which is provided in the link in the conversation communicated to every judges. Sir, Mithun sir, it is very good day for us with you. You have been enlightened all aspects. Thank you, sir. Thank you once again. Thank you, our learned brothers and sister judges, for your valuable time along with us on this leave occasion. Even though you have participated more fully, and the question also very nice to elaborate us in all practical ways. Thank you. Thank you once again on behalf of the State Judiciary, on behalf of the High Court, and also on behalf of the State Judicial Academy. Thank you once again. We will meet again in the next meeting. Thank you.